Good afternoon and welcome to the April 16, 2025 Whole Board Governance Training Session. And let's welcome our trainers, Ms. Nina Gupta.
Hi, everyone.
And Suzanne Wilcox.
Hi there.
Hi.
You ready?
We're ready.
All right.
So we know you have the post-lunch sleepy, so we're going to try to keep it peppy for you.
We'll do our very, very best. Thank you so much for having us here. It's lovely to see you all in person. I've seen you all virtually. I watched some of your meeting yesterday. You have a lot going on. So it was very, very interesting. And thanks for having us again today as well. So these are our glamour shots. You'll never see us look like this ever again. In fact, we have asked to have them replaced because they look so little like
No one
us.
recognizes us.
It's not good. But anyway, we are from the law firm of Parker Poe. You have what we call a placemat in front of you with our, again, lovely glamour shots. Better pictures of our entire team. We are at a firm that has 8 offices throughout the Southeast and Washington, D.C., one of which is in Georgia and Atlanta. And then also we have about 50 attorneys firm-wide. We have about 275 attorneys throughout the entire firm, but 50 attorneys firm-wide that do education law. And then in Atlanta, we have at least, 30?
I would say about 30.
About 30 attorneys that are based in Georgia that all they do is education law. And Nina and I, all we do is education law. And I've been doing it my entire career. Nina, most of her career.
Likewise.
And we have been working together as frickin' frack for about 23 years,
yeah.
Something like that. It's my work wife.
As long as I've been married to my husband. So.
Yes, that's right. Same for me too. So we represent all educational entities. We do not do the other side. We only represent the educational entities. That includes K-12, large districts, small districts, also charter schools from time to time. Not many of those, but a few. And then we also have some post-secondary universities and then trade schools, things like that, and a few corporations that serve educational entities as well, like technology companies, things like that. We represent 94 school districts. I believe it's at 94. That's the latest and greatest. In the 90s, maybe a little higher than that. And they are all sizes. We have very, very large school systems like Fulton County Schools, Atlanta Public Schools, Cobb County Schools, and then we have very, very small school districts that just have one high school, one middle school, one elementary school. And we really enjoy serving all sizes of districts because they all have unique needs and we like to be of service. Most of our attorneys on our team have some personal connection to education, whether that's family that are in education or whether that is they themselves have been educators. Our attorneys come to us because they have a passion for education. As you all know, education is not going to make anybody rich or famous, and that's okay. We are here because we have some connection and we want to serve the entities that serve children. I always tell people, my brother is in instructional technology, my sister's a professor. I wasn't smart enough to do that, so I have to be a lawyer that serves them. So. And that's a little bit about us. Yeah.
I'm a little offended now.
I'm sorry. Except for you. You would be the smartest one.
You're on
That's
one
right.
star right now.
I know. Sorry, and we understand that you're just deducting from our stars from here forward. That's fine. We understand. We are going to be looking at 3 separate parts today. We're giving you your whole board governance training. You have to have 3 hours. However, we are going to take a break in the middle so you can stretch your legs, get a little stretch, and during that time, we'll give you some kind of task so you still get credit for those 15 minutes you walk around. We will be as punctual as possible. We do not like to infringe on your time, so we'll get you out of here on time. Well, as on time as 3 hours from when we started would be. There you go. We'll take it.
Okay.
We'll take it. We'll try. We'll do our best. Status of Title VI guidance, right? That's a hot topic that everybody wants to talk about. We're going to talk about student discipline best practices. Just a few tips and tricks. We won't spend a ton of time on that, but there's always a few things that we've seen in all the school systems that we represent that we think can streamline and maybe help some understanding of little things that seem to be hot topics at the state board and our clients have been asking about quite a bit, so we've added those here for you. And then always, since it's whole board governance training, the role of the board member, governance in general. We're going to focus mostly on red flags, not necessarily things you all are doing, but things that can get you in trouble. And so if you're looking for a way to make your life harder, more miserable, these would be things you'd want to put in place. But if you don't want to do that, maybe don't do it. Don't do it. That's right. That's right. So those are the topics. If you're okay with it, what we'd like to do, because we have so much material, what we'd like to do is get through each section and then take questions after each section. Is that all right with y'all? Okay. So write them down as you think about them. And if we don't get to a question that you have or you don't feel comfortable asking the question, you are very welcome to reach out to us at our email addresses. We're happy to do that. I didn't go over this. This is the disclaimer here at the top or here at the bottom. You know, this isn't specific legal advice. You know, if you want specific legal advice, we'd have to get all the details and all the facts. This is could be considered attorney advertising. You know, there you go. There's the fun stuff. Okay, so I'm going to turn it over to Nina. She's going to talk about, this is probably the best graphic to describe this topic, what we all want to do, and also pretty much summarizes our advice on it.
I gotta keep her head down.
Yeah,
It's basically
keep your head down. So I'm
shorter,
gonna
keep her head down.
Turn it over to Nina.
All right, so thank you all. And also, Suzanne's right, we do not want this to be a sit and get. We want this to be useful to you. So please, after the end of every section, we want to have some conversation to make sure this is as meaty and meaningful for you as possible. So as you all well know, there has been a change in federal administration, and that has led to some changes on the ground for schools. Specifically, for example, on April 3rd, the United States Department of Education mandated a brand new certification from all school districts and all state education agencies regarding Title VI. And Title VI is the federal provision that prohibits discrimination on the basis of race in federally funded programming, including K-12 schools, including every higher education entity as well. A lot of the language in this mandate and the accompanying explanation was premised on a decision from the Supreme Court, the Students for Fair Admissions versus Harvard case. How many of y'all are familiar with that? Yeah, it's pretty good. Basically, race-based affirmative action in higher education admissions is unconstitutional. That's what that case held. And by the way, that's all that case held. It didn't say anything about DEI generally, but it did have real language, meaty language, and us lawyers call it dicta, which is just sort of commentary that race should not be considered at all in public life in the entities that receive federal funding. And this administration is leveraging the language from that case from the Supreme Court to put DEI practices under some real scrutiny as potentially discriminatory and violating Title VI. And it gave us less than 10 days to respond to this demand for certification, which has now been extended to April 24th. So we have a little bit more time. So in this letter, that explained the certification, put some meat on the bones. The DOE and the DOJ are signaling very strict enforcement of Title VI. And they say straight out, DEI sometimes violates Title VI. Now, y'all probably are aware also of a Dear Colleague letter that the United States Department of Education issued in, I think, late January, that took a very expansive notion of DEI as violating Title VI. About a week later, they walked it back quite a bit. And I think they understood that you can't make law out of a Dear Colleague letter, but they clearly set their marker on the ground of what their interpretation of Title VI is. They framed DEI as radical indoctrination, and this is a value-free statement from me. I'm just quoting from the letter, and made very clear that continued federal funding is now linked to a strict anti-discrimination certification. Now, I don't want to be alarmist about this. Y'all file a Title VI certification on the regular as a condition of receiving federal funds. Y'all did it last year. Y'all will do it next year. You do it regularly, as does every state Department of Education. This certification, to my mind, is repetitive and duplicative of certifications that you have already provided. You have always been bound to the rules of Title VI. You have always been prohibited from discriminating on the basis of race in any of your programming. That's all the certification really means in its four corners. But the devil is in the details, and we're going to talk about that in a second. So you're certifying that there are no race-based practices at Savannah-Chatham schools currently practiced that violate Title VI, just like it was a year ago, just like it'll be next year, and it applies to everything that you do. But this administration has made very, very clear that they are taking a very expansive view of what Title VI race-based discrimination means. That doesn't mean it's the law, but it is this administration's interpretation. So key focus areas that we know they're going to focus on. Anything that looks or sounds or walks or talks like what they consider to be critical race theory. The word equity seems to be a third rail in a lot of ways. Equity in discipline and counseling. Y'all might remember under maybe now 3 administrations ago, the USDOE had a real push to try to eliminate racial disparities in out-of-school suspensions. And the Office for Civil Rights was very active in pushing that. Those efforts, I think, are going to be rolled back and go in a very different direction. They're going to focus on affinity groups, which are probably very common, certainly in the corporate sector, but also common in K-12 and colleges as well, and also in performance programs, gifted programs, all of those kinds of extra goodies that Savannah-Chatham schools and every school district offers its students. I'm not saying that any of those things are illegal, but what I am saying is this administration has signaled very, very clearly that they are going to look at them with a critical eye, and they're going to get some scrutiny, some real scrutiny. So potential legal exposure for districts related to the certification, there's no real legal exposure that you didn't have before, that you didn't have when you certified a year ago and the year before that and the year before that. But the biggest, hammer or stick that they have is when you provide a false certification that can subject an entity to the False Claims Act, that includes civil penalties, triple damages, potential criminal probes, and of course loss of federal funding as well. How many of you have read or heard or learned about the special investigative team concept that the USDOE is using for Title IX enforcement? All right, so this administration announced these special investigative teams that are dedicated to looking at Title IX enforcement, generally in the area of transgender students and sports participation and single gender activities. And these are teams that are just focused on those issues that come in, and it's almost like a rapid response team where they're dedicated to investigating those issues. They come in fast, they do a real fast investigation, and they come to a really fast conclusion. I think an example of what you can expect is what happened with the state of Maine. The state of Maine has a state law that states that transgender athletes must be allowed to play on single gender teams in accordance with their gender identity. The USDOE came in, said we're opening an investigation, and the next day said you're out of compliance. A 24-hour investigation from the USDOE, unheard of. But that's the kind of speed that they're working with here. I expect that there will be special investigative teams surrounding Title VI as well. I think they're probably going to start at higher ed. That seems to be the big fish, but it is absolutely coming for K-12 as well. There is absolutely a new sheriff in town. They are letting you know it. There's been a lot of activity in just, what has it been, 82 days of this administration. So they're committed to working fast and really making their presence known. So school districts get this letter on April 3rd that says you have to certify by, I forget which date, but then on April 11th, the U.S. Department of Education issued a clarification that was communicated to all of the school districts in the country, or should have been by the state agencies. And it's an interesting clarification. So let's walk through it. First, they said, we're not going to initiate any enforcement action, investigation, or take any action based on a certification or a lack of certification until after after April 24th. So basically, you get an extension. That's not all that meaningful, but okay. Next. Certifications are not effective until after April 24th, and this is key to me, may not be used for any purposes, including but not limited for the basis of any enforcement action, investigation under the False Claims Act, contract claim, or any other basis for liability by any public or private party. So you're a lawyer. What does that mean to you? Yeah. Yeah.
It means I should call you for advice.
That's a great answer. But basically what this is saying is, if you sign this, there's no liability attached to it. The signing it in and of itself does not create any additional liability under any theory, under any law for you. So why wouldn't you sign it, right? I mean, if there's no liability, but we'll talk about that. Keep going. And the Department of Education is not going to initiate any enforcement action, investigation, or take any action based on that dear colleague letter that I mentioned earlier, and subsequent actions implementing the letter, and by that they mean the letter that walked everything back, until after 24th. But of course, that doesn't preclude actions based on Students for Fair Admissions, which doesn't even apply to y'all because y'all don't admit students based on race. So what does all this mean? A couple of things. One, I personally don't believe there's much of a downside to signing the certification. If viewed as duplicative and repetitive of certifications you have already provided. You have always been subject to Title VI. You have always been subject to its codified regulations. You have always been subject to binding legal authority that interprets Title VI. And no dear colleague letter changes the contours of the law. That said, this administration has signaled very, very clearly its intention to test its own interpretation of what Title VI is. And that interpretation is, in my opinion, pretty robust in a way that is novel. And that's going to get tested, and it's going to get tested in court. And the courts are ultimately going to decide truly what the contours of Title VI are, truly what is okay, truly what is not. There is no law, there is no case out there that says DEI is illegal. But there may be some DEI practices that we consider that a court may find violative of Title VI. So the question is, do you want to be the test? I don't know that I necessarily see an upside, but that is a decision that y'all as a board with your superintendent need to make. But I will say I think it is good practice to review your DEI and equity policies for legal compliance. Just take a look at them. And here's what I will also say. There's a lot of attention paid to words. I think there's less attention paid to what actually happens on the ground. If you can get done what needs to happen for kids on the ground and keep that good work going for all kids, including kids who might be the most challenged of your population, without using trigger words, that might be something to look into, to do the good work instead of saying you're doing the good work. You want to communicate very carefully with your staff and your families and the public. Certainly, you want to make sure everybody knows everybody is welcome here in Savannah-Chatham schools. Every child is going to be treated as a precious gift that they are, and we're going to value everyone that walks through our doors. You can also consider inclusive efforts that aren't tied to race and gender. Those are not the only two characteristics where some of our students struggle. We know students with disabilities are often significantly challenged in ways and sometimes overlooked in ways. Our English language learners, our low socioeconomic students, and of course, lots of kids fall into more than one category. And inevitably, prepare for some potential investigations. They're coming. They might not come for Savannah-Chatham, but they're coming somewhere. And again, ask yourself whether you want to be the test case or not, or whether you just want to kind of keep doing the good work on the DL. Train your leadership on federal standards. It is changing every single day, but it behooves all of us to understand where this administration is coming from, because they do have the purse strings and they're not afraid to use them. Exhibit A, Columbia and Harvard and Brown. And then consult our State Department of Education and your legal counsel as well for best practices and guidance. We are all figuring this out together because it's very new, but there is strength and comfort in doing this collectively. Now, of course, we know this is part of a larger federal campaign that targets race and gender conscious programs, not just in education, but in private industry as well. There are similar warnings that have been issued to colleges and employers, and some colleges and employers have actually reached agreements with the administration to eliminate all DEI programming, scrubbing websites. I'm sure y'all have heard about law firms agreeing to provide hundreds of millions of dollars of pro bono legal work to preferred causes. There are all kinds of executive orders on ending indoctrination. Those executive orders also are not the law. They are a clear statement, however, of this administration's priorities and intentions and should be taken seriously. And of course, the push to dismantle or restructure the DOE. Dismantling the DOE requires congressional approval. I don't know if Congress is going to approve it, but you certainly can break it up for parts, and that seems to be what's happening with student loan financing going to the Small Business Administration. Accreditation may go, or special education is going to Health and Human Services, or at least that's the plan. OCR, the Office for Civil Rights, this investigative unit, may go to the DOJ. I've heard rumblings that maybe it'll go to the Office of the President. So there may be not much of a DOE left, whether or not Congress approves it. So the key takeaway, I wish this worked
try it?
because it's so funny.
Let's try it. Why not? It may.
Next step is to fold in the cheese.
What does that mean? What does fold in the cheese mean?
He folds it in.
I understand that, but how do you fold it? Do you fold it in half like a piece of paper and drop it in the pot, or what do you do?
David, I cannot show you everything.
Okay, well, can you show me one thing?
Here's what you do. You just fold it in.
Okay, I don't know how to fold broken cheese like that.
And I don't know how to be any clearer. You take that thing that's in your hand, and you...
If you say fold in one more time.
It says fold it in.
This is your recipe. You fold in the cheese then.
Don't you dare.
You fold it in.
David!
So we've been using that particular clip for a while, including during COVID, when we were getting all the guidance and nobody really understood what it meant. But it just has so many applications. So it is our best advice is basically to fold in the cheese, which is unfortunate. When we got the word about the certification, we were actually at the Council of School Law Attorneys Conference, which is a national conference where all the school law attorneys come together. We were all in a room together. We immediately descended upon each other and try to figure this out. It very much took on the life of fold in the cheese. But you could also say maybe that's the guidance we're getting from our friends in Washington as well, to fold in the cheese with not really a whole lot of information to back it up. Do you all, and I apologize if I am giving you information that you already have, do you understand the landscape of the different types of guidance and legislation we're getting? I'm gonna walk you through it really quick, and if this is oversimplification and you already know it, then I apologize. You have federal law. Title VI is federal law. Federal law is very broad. It says a lot of very broad things. It's usually really, really short, right? Don't discriminate based on race. Okay, great. But what does that mean? Then we have federal regulations that are supposed to expand on that and explain it. And those used to be things we could really rely on and we could hold on to, and we could treat almost like they were just like law. However, what is called the Chevron doctrine is now no longer a thing. So now courts no longer have to give the deference to federal regulations that they gave in the past. So whether federal regulations are a protective space for us, still a question. Would I continue to see that as very persuasive and something that we should continue to abide by? Yes. But is it possible a court could come in and say, that regulation, who cares? We don't have to look at that. We're going to go back to the beef, the law. Then you have executive orders, which Nina's already addressed. Those are not law, but they are statements of policy from the presidential office, and they are also guiding the federal agencies and how the work will be done. So it's important, but not law. Then you have certain agencies will put out guidance, like the Dear Colleague letter. That's actually from the DOE. Officer of Civil Rights, I believe, is the one that put that out. And that's even lower down the totem pole guidance, but it's still something we have to pay attention to because, again, it's this agency saying this is how we're going to go forward.
And sometimes those policy positions really do make a huge difference immediately on the ground of what happens in day-to-day life. And I'll use this as an example with the immigration enforcement. It used to be that churches and schools were considered protected spaces by the Department of Homeland Security. So they would not try to enforce immigration laws in churches or schools unless there was a real emergency that was exigent, immediate, et cetera. And that was the policy of DHS. That policy has since been rescinded. And it is up to the DHS to decide that policy for themselves. So now we are seeing enforcement happening in churches, and we are seeing enforcement happening in schools. And this doesn't have anything to do with a Title VI certification, but my best advice to you is to make sure that your schools and your administrators are ready to deal with a federal immigration enforcement agent who may show up at a school, because their authority is different now, and they need to know how to react to that.
And one thing that, when I was going over what we do, one of the things we do, you have legal counsel. Obviously, you have a board attorney, you have internal counsel, you have legal counsel. One thing that we do from time to time is we work, if asked, we worked with either your inside general counsel or your outside board attorneys if they have capacity that they would like to add, or if something is complex. So it's not uncommon for attorneys to work together in these spaces. But I think what any attorney would tell you is to keep an eye on what's going on, to audit yourselves to see what you have and what you can fix that might have some of this trigger language in it, and how can we address that. And I know you're already looking into those things, or at least it seems like you're already looking into those things, which is great. And then just making sure that you're staying informed. It is every day. Every day something changes. So we have alerts that we can sign you up for, but there are lots of different alerts that you can sign up for as well. Just going to the DOE website and checking the news releases is a really good way to stay informed, as are going to the executive order website and seeing what's dropped, because several, it seems like, are dropping every day. They're not that long. They're a couple pages long, so some are longer. But hopefully that will give you some sense of what's going on. I say, yes, keep an eye on the media, but sometimes they don't give you the full story, or they just give you a sound bite. And for what you all do and the deep work you do, it's not going to be enough information. So really going to the source, to me, seems like the best way to do it. But it seems like you are already thinking the right way. And so continuing that work to continue to think about what do we need to do and paying attention to what's going on, that's going to be your best defense as this goes on. And I will say, I think part of the, and Nina didn't mention this, but I'll say it, I think the folks that don't sign the certification, that might be a shorthand for them of who should be the next group that they look at. Right. We know there are full states that are refusing to sign, like New York. Other states have basically given the signal, the Heisman, as my husband would say, that they're not going to participate, like Maine. So, watching what happens to them and understanding that sometimes when you stand for principles, PALS, they can be expensive and they can get ugly. And so I think that's what's happening in those states, and paying attention to how that goes will be interesting. And again, if you want to be the tip of the spear, there's opportunity for that. But I think most school districts do not have an appetite for that, and they just want to continue to do the good work without a target on their back.
Right, right. And there will be litigation about this Title VI certification, DEI programs. It's probably going to come out of Chicago or New York or Denver. Some of those school districts are being very loud and proud about wanting to sort of resist, I guess. And this administration is not afraid to go after the big fish. They've gone after Columbia. They're going after Harvard. They want this fight. They want an answer from the courts. So we're going to be watching that closely as well.
Okay, I think that's the end of this section. Yep. Is there anything we can answer for y'all?
Dr. Hoskins-Brown, then Mr. Kachmar.
Yes, thank you. I appreciate this presentation and your interpretation of the information. I've been living part of this in my other job. I'm a federal employee, so I'm seeing how dates and things are being enforced. I really like the suggestion that someone should be looking at this first person and studying it. There's certainly people whom I know that that's what they're doing. They're consuming all of this information through executive orders, interpretation of policies and memoranda that come down, and then interpreting it for others to make sure that it's being consumed. So my question is about programming that at some point later on is seen not compliant with this policy. And I have an example from a federal agency. So I have a colleague who had grant funding for a research and education program that was very clearly about including marginalized groups. They moved forward on that because they had not gotten the cease and desist, stop doing those activities yet. So they paid tuition for the following semester, these things that you have to pre-register for, paid the tuition, authorized the stipends with the belief that what had already been encumbered or spent was not available to be recalled, and that if the cease and desist came, which they knew would probably come, that it would only be for forward actions. What they found was that wasn't the case. So they wanted tuition unspent, and they recalled everything. Everything should stop after this point. So my question is, for us, do we expect to see that sort of thing in programs that are aligned with Title VI, this idea that not only must you stop, but anything that was authorized under the triggering program has to be reversed after that date of us being called on it? Does my question make sense?
It
Okay.
absolutely makes sense. Like, basically, is there a clawback? And I see no reason why there wouldn't be a clawback, or at least an attempt at a clawback. If the theory is that this programming violates Title VI going forward, you should never, it was unauthorized spending previously, because it still violated Title VI previously, so you got to give the money back. Just like with Title I money, if it's not spent, you got to give it back, and there's a penalty for it. It's a possibility. I don't know how realistic it is. I think there's a different appetite, and this is me completely speculating, by the way. I have no inside information on this, but I think there's a different appetite to go after entities that might have billion-dollar endowments versus entities that rely on property taxes almost exclusively for their funding and are educating little kids, that is, and providing an education that is seen as sort of the de minimis of what anyone should have, a K through 12 education. But that's not to say it's not impossible.
Okay, thank you.
Mr. Kachmar.
Somewhat related, you mentioned that there was a, hey, if you sign anything before the 24th, we're not going to do anything about it. But you, in the language there, you said public or private. Was that also an effort to kind of cut off any private whistleblower claims against districts for misspending Title VI money or anything like that? Are those even viable?
So I don't think private claims are viable. These are federal funds. I think a lot of this work is being done pretty quick.
Yeah.
And that doesn't always lead to exactness. So, you know, perhaps the public or private, it's like, let's just throw everything in there and let's let LEAs know that this certification really doesn't create any new or any new liability, regardless of where you think it might come from.
And it's possible that they might inartfully been trying to refer to private organizations that are taking the public money for Title VI. That could be what,
Like partners that are working with school districts.
when we got the
Like,
clear.
because we,
Oh, go ahead.
we work with outside, we work with third parties to provide services that we don't
Absolutely.
provide that may or may not be defined as DEI.
Right.
And
And they are receiving, if they're receiving federal grant money, they're going to be subject to this, even if they're a private organization, obviously. And if we're paying them, then
But is it federal, is it
indirectly,
any,
obviously.
is it federal grant money or any federal money?
Any federal money.
Because we spent money under the $100 million American Recovery Act on all sorts of stuff.
It's any federal money. I mean, remember when the feds went after Maine, they didn't just threaten their Title I funding or Title VI funding, they froze nutrition funding.
That was their first,
So,
that was their first shot across the bow, was to freeze funding for school meals. So, and that was a Title IX issue.
right.
Had nothing to do with you know, agriculture or anything like that. Great question.
Anyone else?
We're not really sure. And honestly, when we got that clarification, I sent it to Nina and said, what is your take on this? And she said, gobbledygook. And I was like, yes, there's a little bit of that. But when you parse it out, you can kind of see where they're going with it. But I do think these things are happening fast, and it may not get vetted in the same way for clarity that other documents might that come down. Other questions?
I think we're good.
Okay. Well, I'm glad that that's clear as mud, and I'm sorry that we don't have more detail, but there will be more detail because it's happening in real time. I will say this, and some of our clients are considering this. You may want to consider it too. Federal lobbying presence. And I'm not talking through NSBA or COSBO or GSSA or any of those things. I'm talking your own bespoke person, as you might have going to the Capitol and checking in with folks or helping your folks get access. There is a conversation happening about whether school districts should make the investment. It's not a huge investment, but the investment in a federal lobbyist that will help them navigate some of these things, maybe open doors if they become a target and they shouldn't be, that sort of thing. So that's just something to consider. We have a couple of lobbyists in our firm that we've been talking to, and they've been giving us so much better detail than we're getting from the public, which has been really helpful. And it's also important that they be on both sides of the aisle, and they are. So we have one on one side of the aisle, one on the other, and they are able to feed us information that's been really helpful. So you may want to consider that as this goes along. Just a little thing. There's plenty of folks that do it. It just may be something that you find helpful, if nothing else, to feed you information.
And if you do want a free resource, do sign up for the client alerts. We also have an executive orders team
Yeah.
that is keeping track of every executive order that comes down by subject matter, by agency. So we've got plenty of analysis on those education-related executive orders. So feel free to sign up for those alerts as
Yeah.
well.
Absolutely. All right, moving on to student discipline. This,
I'm glad someone else enjoys this. This is
I know. This movie, and I can't remember the name of it. Is it Teacher Fight or something? I don't know. It's hilarious. It's a classic. It's not appropriate, I will say that, but it is very, very funny. And when, you got to have a sense of humor. So, all right. So we are, let me back up because that's going to get weird. That's going to get weird too. So one of the things that I have been getting tons and tons and tons of questions about is student discipline lately. Things are happening in student discipline. Since COVID, we all know,
stop that. It's very distracting.
it is very distracting. And I don't know how to, I'm going to go back to this one because the other one is also distracting. So we're just going to stay there. Since COVID, our students have been, for lack of a better term, going through it. Discipline, I don't know what your discipline rates are, but I suspect they are up. I also suspect that kids are becoming more creative in their behaviors. I also suspect that community behaviors are on the rise. Now, that's been true since I started practicing law in 2000. So I can't imagine that's changed, but it just feels like since COVID, everything has ramped up. Families have become more, I feel like there's more tension. It's just gotten a little bit harder. And at the State Board of Education, our appointees at that level who work very hard, they have taken some positions with student discipline that are different and new. Maybe not, depending on your perspective, in a good way, right? Getting a little more granular on some topics that have been settled for a couple of decades. Things that we're going to talk about today. So the topics I'm going to kind of hit with you all today are the things that I'm seeing and our team is seeing getting a little more traction at the state board than normal. When I first was hired as an education attorney, all I did was discipline for many years. And I am proud to say that I never lost a discipline case. Yay. But I don't do the discipline anymore because I'm dealing with the nice board members like you all mostly. That is no longer the case. Now, I will say this, if a student never wins a case at the state board and they never win a case at a school district, then there's probably something wrong, right? Because it should never be a rubber stamp. It should never be 100% that the school always wins and the school district always wins at the state. Totally understand that. But there's been some changes. So we are taking some proactive efforts to understand those changes and to train our clients for those changes. And you will hear a theme, and I think you've already heard it, training is important. It's also not it's important for y'all, but also for your staff. It's also not always super popular because our educators, they are heroes and they have so much on their plate and they have so many topics that people want to talk to them about. But preventative legal training in some of these areas is so important and will save you lots of headaches, will help children and make sure we're not running afoul of the law and we're not doing anything to kids we're not supposed to be doing as far as like due process and their legal rights, but also will save you money. A little bit of training goes a long way economically as far as mistakes that get made and how much they cost. If you spend a little bit of training and you avoid one lawsuit, you've recouped that money times 10, right? Lawsuits are very expensive. To take a federal case from beginning through a jury trial is easily $500,000 to $1 million in this day and age. It is, and that's at a very...
The lawyer is smiling.
The lawyer's like, really? You don't say.
That's Atlanta rates.
Yeah, actually, that is reduced school district rates. It can still go that high. Now, we work very hard with our clients to keep that amount down. But the problem is, not only is there more tension with families, opposing counsel has gotten very aggressive. And sometimes when you get in litigation, you cannot control, for lack of a better word, how wackadoodle your opposing counsel gets and how aggressively they may litigate. They may ask for 20 depositions. And we have to do 20 depositions, and those get expensive. So avoiding that through training, a big focus of what we do, and we encourage you to adopt this if you haven't already, and maybe you already do, proactive. How can we stop it before it starts? And training is a big part of that. And that's what some of this conversation with discipline is about today.
And one more plug for training, to say nothing of the cost savings, which are important,
Right.
but making good decisions that your staff can explain to people who may not be having their best day also helps preserve relationships and trust. And you're going to have these families for 18 years, hopefully, with one child. That is a long time to not trust each other. So if you can avoid that and have a truly collaborative partnership with your families, because your staff is making good decisions, because they know what the right decisions are, and they can explain them, that goes a long way as well.
Someone described it once as a divorce where everybody has to stay living in the same house. That's true when you have special ed or discipline fights. That's sort of what it's like when you have a high conflict situation with a family. So if you can avoid that, cut it off before it gets too bad, that's your best bet. I'm not saying don't litigate. Sometimes you have to. If you roll over too fast, it's a balance, right? If you roll over too fast, you become a target for folks that want to get that quick payday. But if you are constantly litigating everything, you will go broke very, very fast. As you said, that's some expensive rates. And that is not what you should be spending your money on. You should be spending your money on students and their achievement. Okay, moving on. All right. So one thing we have seen get a lot of attention, and this has been building, is this idea of physical offenses. And when it is self-defense and when it is not. Okay, so on the left we see Lilo here attacking someone. You see that the person being jumped on under the battery category is just receiving the beatdown. Okay, that is a battery. That is someone getting attacked, and we'll talk about the legal definition there. And then you have self-defense, right? Miss Congeniality over here.
Best movie ever made.
It's a very good movie, yes. Again, this is just a parade of our favorite shows and movies. Is being attacked, sort of, by someone, and she is defending herself, self-defense, right? She's trying to get away from that person. That's a big distinction. And the difference in what can happen to a student is very dramatic, okay? All right, this is a lot of words, and I'm sorry. There's really no way to make it less words. Battery, how many of you all feel like you know what battery really is under Georgia law? It's okay if you don't. More fun, and we're not going to get into this too much, is the difference between assault and battery. Assault, just because it's my pet peeve, and it drives me crazy when people say assault and battery like it's one thing. It can be, but they really merge into battery. Assault is when I go to punch you, but I don't hit you, but you think I'm going to. Okay, that's assault. You have this fear.
It's the threat.
It's the apprehension of about to be hit. Battery is the contact, okay? There's two types of battery in Georgia. There is simple battery and there's plain old battery. The first at the top of this slide is plain old battery. And that is when you cause substantial physical harm or visible bodily harm to somebody. So basically, I have to be able to see it. It has to be real, like a big black eye, or you got swollen lips or something like that. That is going to be regular battery. It's a misdemeanor in Georgia. You have that in your behavior code. Okay, you have a battery charge in your behavior code. Simple battery is the lesser, less exciting version of that. And that's just when you make intentional physical contact of an insulting or provoking nature with somebody. That can be me flicking someone's head. It can be anything minor. Battery can also be putting an object in motion. If I pick up a chair, unfortunately, we've seen this scenario way too many times with our clients. If I'm a student, I pick up a chair and I hurl it and it hits somebody, that is also battery because I put this object in motion and it is hitting someone. Even if I indiscriminately just threw it and didn't know if it was going to hit someone, if you have a reckless disregard, then that's going to be battery too. So you're going to get in trouble. If you throw a brick into a crowded room, you know it's going to hit somebody. You're going to get in trouble for that. You don't have to necessarily have a target in mind. All right, so that is what battery is. Now, fighting, you all, from my review of your behavior code, you don't have a separate fighting charge. Some districts do. And when you have a separate fighting charge from battery, it gets broken down. Like battery is just sort of like the attack, the Lilo attack, where I'm just standing there and someone jumps me. Okay, that's battery. Fighting would be a mutual combat situation where both parties are going out, they're both going to be in trouble. It's okay not to have a fighting provision. Some districts do, some districts don't. You don't. You have battery and you have assault. But all of these physical offenses, and you can batter an employee, you can batter a student. There's all kinds of ways you can batter someone in school systems. But the thing we have to remember is self-defense. And I don't need to know the names or any details about it, but how many of you have had disciplinary appeals? How many of you remember a disciplinary appeal where the student's defense was, I was acting in self-defense? Do y'all remember anybody bringing that up? I'm seeing some nods. Okay. It is a very common thing that families will bring up on appeals to boards. I was acting in self-defense. Now, some of them are really a little bit funny. Like, I was walking away, my favorite case years ago. I was walking away, a kid was walking away from another kid, and the second kid who was behind the kid took one of those old, like, thick Snapple bottles that were like real thick glass bottles. Y'all remember those? I don't know, I'm dating myself a little bit. This was like in the early 2000s. Took that thing and hit the kid on the back of the head as he was walking away and said, the kid who hit the other kid said, self-defense. We were like,
That is not what that means.
that is not what that means. He had a very famous aunt. The aunt came and testified on his behalf. It didn't work, unfortunately, and he was found guilty. So the reason that students will hit the self-defense so hard is because if they can prove self-defense, you actually cannot discipline them at all for the behavior. Your policy rules go out the window. If a child is truly acting in self-defense, there is no discipline to be had from that.
And that makes sense, right? Like, you don't want to discipline a kid for not getting the crap beat out of them and protecting themselves.
Right. So a savvy attorney or even a savvy parent will say, well, it was self-defense, so I can't be disciplined. And if it's true, they're right. There have been a number of cases at the state board as of late regarding self-defense and what self-defense is. I think some of them walk the line a little bit, but there we are. They've taken a relatively, not hugely broad, but a little bit of a broad view of what self-defense is. And they've also made it clear, let's say two kids get in a fight, and that fight causes a disruption. So you charge them both with battery or the fight and the disruption. And one student proves, I was acting in self-defense. I was just trying to get away, basically. That's all I was doing. Then the disruption charge must fall away as well, because the only reason the disruption happened is because you were participating in self-defense. So how can I have disrupted when I was just trying to protect myself, right? Is this the he started it defense? I would say no. It's more complicated than that. I would also say that true self-defense is pretty rare to see. We don't see many of them by the time they get to your level. Because number one, your wonderful principals and your assistant principals, of course they've been trained to recognize what self-defense is. And when they see it, real self-defense, they say, I'm not charging that kid with anything. He didn't do anything wrong, or she didn't do anything wrong. She's just defending herself. Trying to get away is the most common situation where someone attacks you and you are pushing them off and maybe hitting them just to get them off of you so you can run away, right? That would be a situation where most experienced administrators would say, we're not charging for that because it's self-defense. But there are times then when they do make it up to you, or we'll have board members ask, what is can you define it for me? It's not easy it sounds like it should be easy to define self-defense, but the law has a very, very wordy definition, and I just wanted to provide it to you so you have it, right? So here it is on the right side here. You can threaten to, because threatening people is also a crime, right? You can threaten to use force or actually use force when you have to be a reasonable person about it, not just me acting wild and woolly and thinking that somebody that blinks at me is trying to, hit me. It has to actually be a reasonable thought that someone is going to hurt me and I need to defend myself against an imminent use of force. Okay, and that word imminent is important because somebody walking away and me hitting him with a bottle and saying, well, I thought maybe he might turn around, and if he did, I wanted to be ready, so I just went ahead and hit him in advance. That's not enough, right? It's got to be imminent, like someone is coming for you in real time, all right? But the law excludes situations where you provoked the use of force with the intent to use that force as an excuse to commit bodily harm. What does that mean? That's a lot of words.
You started it.
Right.
You can't start it.
Right. Or when a student taunts another student, come at me, hit me, I dare you, hit me, because they want an excuse to start that fight, right? And we've seen it. We've seen it. Kids are smart. They are smart, and they know how to push the buttons. And so if you find that they have provoked it, then that is not self-defense. And what I don't have on here, and I always say in my trainings with staff, is just because you lost the fight doesn't mean you were the victim. If you participate in a fight and you pick a fight with a big dog and that big dog bites you, you just lost the fight. You did not, right, you did not fight. Yeah, that's a hard lesson, and maybe pick better fights or take some kind of class, I don't know.
One thing we see pretty frequently with these or at least I've seen it pretty frequently with these self-defense arguments, is my kid was being bullied by the other kid.
Right.
And there was mean stuff about my kid on social media, and they felt really bullied, and they felt afraid of this person. So that's why they brought the knife to school, to stab them just in case something happened. I'm not saying that's not a real worry, but it's also, it doesn't fall into the category of self-defense. But that's a thing that comes up pretty frequently, tying self-defense to bullying.
And often, not just with knives, we've heard that with
Guns.
firearms as well. And families file this under maybe too much information, but we'll say, well, what, son had a gun, or your daughter had a gun, or your daughter had this weapon or that weapon. And they'll say, yeah, they needed it for self-defense. So essentially saying they plan to use it. That's not better. That's worse. And that is not self-defense, planning to hurt somebody in advance just because there is some kind of history, right? That's not going to be, this idea of bringing a weapon to protect yourself is not going to be an excuse for bringing a weapon to school. Now, is it something we need to potentially deal with? Is there some kind of bullying or something? Yeah, that doesn't negate the fact that perhaps that other student is going to require some discipline as well. But that will not excuse the idea of bringing a weapon just because you think you need it to defend yourself. Okay, so we know you can't provoke it. The come at me defense is not going to work. Is attempting to commit, is committing, or fleeing after the commission or attempted commission of a felony. So let's say they steal a kid's cell phone. They walk up to him, snatch their cell phone, start running. The other kid comes up behind him, grabs him, throws him down, and they start punching the kid who threw them down, trying to get away. And then they say, self-defense. Self-defense. He was hitting me. He was hitting me. I was trying to get away. Well, assuming that it was a felony, which is another question, whether or not stealing a cell phone, although some of those cell phones are so expensive, it could be a felony because those things are really expensive. But if they were in the middle of a felony or they were trying to commit a felony, then that would not be an excuse either. You can't claim self-defense when you were doing something really, really bad at the time, all right? And then this last one I think is the most common, was the aggressor started it or was engaged in combat by agreement. So you're in a fight. If you're in a fight, that is not self-defense, right? What I just said. If you're the little dog that picks the fight with the big dog, you're in combat by agreement. So that is not going to be a situation where you're going to be able to claim self-defense. Unless, and I think this is kind of funny, and I've never seen it, and maybe Nina's seen it, I've never seen it, where someone says, effectively communicates to the other person they're fighting with that I am intending to remove myself and I do not want to fight with you anymore. And from that point forward, I'm just defending myself. I've never seen it. I would love to see it. I think it would, we all see the videos. I think it would be a really interesting video to watch. But it would have to be something like, I do not wish to fight with you any further. Please to cease hitting me. That's what it would have to look like, right? Clearly communicating.
Uncle.
Right,
And
that could
then,
be something like
yeah.
that. But the problem with that from a discipline perspective is, what were you doing prior to the uncle?
Right.
You were fighting. So you're already in trouble. You might as well finish the drill, I guess. That stopping is not going to get you out of it. It might lessen the discipline. To be fair, it might lessen the discipline. If one student says, okay, let's stop. Let's don't fight. I don't want to fight with you. I don't want to fight with you. And the other kid continues to attack them, and it takes 5 teachers that pull that other kid off and they keep breaking loose and trying to come after the other kid. The other kid has stopped. Yeah, that student that's really going crazy may have to get more discipline. But generally, it's probably not going to excuse you all the way, which is the goal most of the time when we deal with this. If it's true self-defense, as we've talked about, you cannot discipline. There have been a few cases, more than in the past, that have gone up to the state board and they have found self-defense. So it is important, no matter how ridiculous it is, and sometimes it's really ridiculous, if you get an appeal, to truly consider the self-defense argument, or at least give it a moment to think about it, and then to make it clear in your decision that you have considered the self-defense argument and you have disposed of it because you do not believe it's self-defense, and moving on. You may already be doing that in your board decisions. If you're not, it's just a little line you can add if you want to sort of shore up, because one of the cases they had, the state board noticed that there was no indication that the board considered the self-defense. Well, it was in the student's argument, and they found against it. I would argue, yes, they did. It was in the record. Like, the self-defense argument was in the record, so they considered it, because you have to consider the record. But the state board really felt like there should have been a specific nod to self-defense, and there wasn't. So you can easily dispose of that by adding that to your decisions when a student claims self-defense. I will say, again, I think real self-defense is rare, especially when it gets here, because by the time it gets to you all, like 20 people have looked at it usually. And if there's a problem, they probably would have pulled it by then. Either your legal counsel or
I just I hate to interrupt, but Lester Johnson has incorporated that as part of the process with our hearing officers. So that piece has been in effect for 3 years whenever that decision came out.
Wonderful. Yes, that is exactly what they should do. And I'm glad to hear. And Mr. Johnson, I know him well. He's lovely, just a really kind man. And I know he does great work. So that's great to hear that y'all are already doing it. But I get, even in districts where this has been in place, I get this question so often. So I wanted to make sure that y'all had a good explanation of what self-defense was and had that in your arsenal if you need it. Any questions about that? I want to take the questions at
Ms.
this.
Hall and Dr. Hall.
Thank you. Unfortunately, it has not been my experience in a career over 35 years that this is how things are really dealt with at the school site. Now, cases that might come all the way up to us, I can see where your arguments come into play. But in most cases, what I have seen, especially when I was an assistant principal dealing with discipline, is that the administration is so incensed over the disruption that both children receive identical punishment regardless of who started the fight. Usually by the time an adult is on the scene, the fight is in full motion, so that who started it is, unless you have, some eyewitness, like on Gunsmoke, there's always Louis was there and saw it, but in most cases, you don't know. So both kids, and I mean, that's across, I'd say that to anybody. Chicago, Beaufort County, Savannah, that's what happens. That kid who was not initiating the fight, because she's not going to let me just push her and let her go. Of course, she's going to come back. But for some reason, by the time the adult gets there, she's as much at fault as I, and we're out of school for a week, and it was not my fault. So the training is going to have to really filter down, because that's not usually the case.
And it may be that there are times when the school says, you're both so much at fault that I'm not that concerned about who started it. But if there's a huge disparity, there are times when it's appropriate to take that into account. It's case by case determination. But yes, sometimes training on that topic is helpful for schools.
Okay. And the other part is, this is more a question. It got to the point where the adults who decided to get involved and break up the fight they end up receiving battery. So that changed the whole, instead of just me and Sean fighting now, well, I hit Dr. Watts. So now I'm in trouble, not just for my fighting Sean, but because an adult. So that's the other part of this. When an adult inserts herself, what should be the outcome for that kid? Because she was not invited to get into the fray.
So that really depends on the circumstances. We know that, when a kid is sort of in the red zone and they're fighting, they're not necessarily aiming all that accurately, and maybe someone gets hit by accident. I don't think it's unreasonable to take that into account.
Right.
But there are also other times when a kid says, "Oh yeah, you think you're gonna fight me too?" And they're very intentional about where they're aiming. And that should be taken into account.
And sometimes it comes down to what happened, right, to the teacher. Like if the teacher is walking away with a broken arm, it's gonna be very difficult to say, it's just an accident, sorry. That is something that has to be dealt with. I have seen school districts do it lots of different ways. It's always fact specific, always fact specific. You've got to look at exactly what happened in the situation. And that's why you're required by law to look at the record and to examine the record and make your decision based on that and not just your general feelings about a situation. But one of the things that I have seen be applied by some school districts is what we call transferred intent. You meant to hit somebody. You might not have meant to hit your science teacher in the face, but you did. And so therefore, because you meant to hit somebody, you're going to get in trouble for the hitting of the student and the hitting of the teacher. But it really just depends on the situation that's happening. There's no one size fits all, but always truly consider what the student is putting forth. There are also situations, piggybacking off of that, where we look, let's say we have a battery of a school employee, and the start of that interaction was not as we would have hoped it to be. Let's say a teacher says, "Give me your cell phone," and the student says, "No." And that's where we're going with the cell phones and technology and all the things, and they're very attached to their cell phone, and they're not allowed to have it. Let's say it's a K-8 student, and we say, give me your cell phone," and the student says, "No, not going to do it." Rather than following, whatever processes the school has laid out, the teacher lunges for the cell phone and kind of tackles the student, tries to take it away. And then the student, seeing red, gets very angry and starts beating the teacher. We've had this exact scenario probably 10 times in the last few years. The board will always say, that is not the way we want you to handle kids, right? That is not our expectation for you. Let's don't tackle kids. But also, child, we do not attack teachers and beat them up, right? So we're both sort of in the middle. Those are two separate processes. And I always tell boards, you got to separate those out. The student discipline is for the student. But if you read a case and you say, whoa, this looks like our staff may need some training, or maybe this wasn't handled in the way, then that's when you turn to your superintendent and say, can you look, and maybe it's already being looked into. Maybe it's already been referred to HR. Maybe it's already being investigated. But that's when you turn to your superintendent and you say, we really, the student did something wrong. We'll deal with that. But can you please deal with the HR issues that we're seeing here? Because there are times when a discipline case does highlight some deficiencies that a staff member, or maybe just we need more training on this. That's not something we feel like we have adequate support for, maybe. So that's a good question. The employee piece is always touchy because you want to support your employees. Obviously, you won't have any if you don't. But you also have to deal with what's best for the child as well, and making sure you're giving age-appropriate, progressive discipline for the student. That's a great question.
Dr. Howard Hall, then Dr. Bringman.
Yes, how far can you take taunting? For example, get out of my face, get out of my face. That person won't get out of your face. You walk off, the person's still in your face, and then finally you shove that person. Who would be at fault when that person provoked and taunted and wouldn't leave that person alone. And so, and you push them, and then it becomes a fight.
So I'm someone who believes that people that cut me off in traffic should be executed. So, I understand.
We call her Blackheart.
And that tailgaters are moral degenerates. But anyway,
You never do.
Did somebody vet these trainers?
sweet face, right?
You never do.
I think
We have concerns.
I think, and I hate to give you this kind of answer, but it's a case by case. Like, am I just getting up here? Think about your kids in the back of the car. I'm not touching you. I'm not touching you. I'm not touching you.
Send you
It's that, right?
Right.
But if we're the two kids in the back of the car, I'm not touching you. I'm not touching you. I'm not touching you. And Suzanne reached over and smacked my hand away, you probably wouldn't get too mad at Suzanne for doing that, right? So I think you just got to take all the, now, I'm not touching you, I'm not touching you, and then she pokes my eyes out, okay, well, that maybe,
Or
you know.
pulls a gun.
Or pulls a gun,
Right.
disproportionate response, right? And I think there are times when someone gets in someone's face when it's clear they intend to start something, that there is a fight coming. So if I don't end it now, I'm in it. That could be self-defense.
Right. And there are things under the law called fighting words that can be an excuse. So sometimes we have to look at that, not to get too deep into that side of it. But there are times when how the fight starts could matter, right? We get a lot of family protecting family. I'm not as sympathetic to that when kids jump in to defend their sister or their cousin or their brother or whatever. I'm not as sympathetic.
You still can't.
Right.
Get it?
You know, if you're standing off to the side and there's an adult nearby, what we expect is for you to get somebody to help that isn't you, because you can get hurt too. I mean, don't forget, it's not just to protect other students in the school and to protect the learning environment. It's to protect the kids that are fighting, because they don't know. I mean, we joke about if you lose the fight, you're not the victim, but there are kids who have been seriously injured because they have jumped into fights, or they have started fights or participated in fights. I mean, we've had kids with TBIs. We've had kids truly lose the use of their eyes or limbs, miss tons of school. Right. And some of our families, we know, do not have the right kind of health care available to them. And so what's going to happen is that student can be able to return. It can be a spiral into a really bad situation. So preventing this as best we can and making it clear that we don't tolerate it sometimes is the kindest thing. Even though it seems mean, it's the kindest thing you can do, because if you can stop students from doing this, you can potentially also, I hate this phrase, but the school to prison pipeline, you don't want to put kids in the juvenile system unnecessarily if you can avoid it. So you want to see what are the things we can do to prevent this and to make sure students know we're going to take this seriously if you do it, because you can really get hurt and ruin your life this way.
Can I try to elevate this a little bit to board governance?
Absolutely.
What are the implications in terms of policy?
Right.
Sorry. What are the implications in terms of policy from these conversations that we're having, so that we can kind of zoom up a little bit?
Absolutely. And that you're actually going, and I don't know if it's in this next one. I don't think it is. You're absolutely going where we're going a little later in this presentation, is talking about your code of conduct and talk about governance, because we know that you don't get the day-to-day involvement in discipline. That, governance-wise, is not for you. That is for Dr. Watts and her team. So she is charged with handling the day-to-day operations. Your goal as the board is to provide that good policy, what is it? Good fences make good neighbors. Good policies make good schools. And I have seen you all, I've watched some of your videos, I've seen you all agonizing over policies and really digging in. That is, I would say, top two most.
That is where you should be.
That is what you should be spending your time on, because those good policies and that good code of conduct is where the real prevention can happen, and the expectations that you, as the think tank of the district, and that's what you are, nobody else can do that but you, it gets pushed down. And when we talk about board governance a little bit later, we get into the reminders about all this is governance. But when we get into the reminders of that, I want you to remember that Dr. Watts and her staff, that's what they get paid to do. That's what they're there for. Nobody can do what you do. There is no one that can do that work. It's just you. And so you want to spend your time doing the good work of the board, which is policy-centered, and making sure Dr. Watts understands your expectations, right? And we'll talk more about that. But that's a great question. I don't want you to feel like it's going to be your job to go to the school and say, let's talk about self-defense. No. But when these come to you as a board, I want you to be familiar with what it means, just as because it is something that the next step of the appeal, the state board has really been focusing on lately. And we actually had an opportunity to do new state board member training recently, and that was very helpful. But you have a number of new state board members that are just rolling on, so they're learning this too. So I feel like some of these themes may continue to roll out over the next course of years because they're learning their roles as state board members.
Dr. Brinkman?
I was just wanting to know policy. What is our policy on faculty, staff inputting themselves in a fight? Do we have policy that says do not, or only if, or is it, because I don't want the answer, it's case by case. I don't, because I think in 2025 it needs to be a yes, engage, or don't engage, or wait for an SRO. Wait, I mean, I don't know what that looks like. I mean, fun HR, yay.
We don't have a directive because, I mean, to some degree, there's also the other side of the Professional Standards Commission, which you're required to intervene. So you have to be careful about allowing something to happen, and you're there. So we don't have anything that says don't.
So PSC says,
well, you're required to do your, you can't allow students to harm themselves. I mean, ultimately.
That's a great point. I don't know many districts that do have policy on it. I think they do train their staff on it, but they may not have a policy on it, if that makes sense.
Yeah, I mean,
I don't buy that if I intervene in a fight, now I know that it's actually part of my mandated certification that I have to intervene. If I get hit, then there is no such thing as an accident because that fight was happening and I'm forced by my contract to intervene. If I get hit, that's not an accident. That's kids hitting me. And I will gladly vote yes on a policy that there is no accidental hitting of one of our staff members because if they by law have to intervene and two kids are going at it or one kid is beating another kid and that teacher gets hit, that's not an accident because that kid knew they were trying to hit somebody.
Well, that's,
Okay,
I think,
hang on, let me, Dr. Hoskins-Brown.
so I think there is a possibility of an accident in a case like that. So we'll do Little Dion at Bartlett, because you know what Bartlett was like when Little Dion was there.
I followed right after.
So, yeah, so when Little Dion was at Bartlett, Little Dion was in Miss Smith's class, and the little girl in front of Dion was being teased by the little girl behind Dion, okay? But the little girl in front of Dion thought it was Dion, so she turned around and jumped me. So in that process, you have the teacher at the beginning of the room. There are a couple of things that the teacher should assess. One, we're sitting in chairs, and chairs are now tumbling because I have been jumped. Hey, Lynetta. But I have been jumped, and now our chairs have tumbled over, okay? Then there are the other children around us. So my estimation, the teacher should be looking at, one, there's this disruption. Two, the potential injury of other children. Three, so it's the safety of everyone around. And then there's also, if she comes over and intervenes, I'm in the process of falling out of a desk. She may be injured as she's trying to rescue me falling out of this desk. So intervening in that case doesn't mean that she should automatically expect that she's going to be injured by an intentional strike. It could be an injury or a strike that comes because she's trying to separate everyone. So everyone in that situation is not throwing punches, is what I'm saying.
I get that. I'm just saying that to me, the aggressor there then, whoever jumped you, would be the person that would be at fault because they were the aggressor. I don't know if little Dion decided to keep going or little Dion said, whoa, I wasn't even a part of this. What's happening? I'm a ball up. But if the teacher got hit for intervening, then I can't see that the aggressor is able to say it was an accident that I hit that teacher.
So I think the policy, and I think this is a right place for a policy that you and I like to go down these rabbit holes, and I know you have other parts of presentation to give. I think the criteria ought to be preserving the peace, minimizing the disruption, minimizing injury to other young people. It could be that Dion accidentally hit the teacher on her way down. So in the process of the investigation, it may be the fault of the aggressor, the one who hit me. I hit the teacher, but it was because I was on my way down or I was in the fray. So the person who strikes the teacher could possibly not be the one responsible for the injury.
Correct.
So I think policies, we can't say you should intervene or you should not intervene because there's risk in each of those.
Sure.
To everyone who's involved. I think our role, if we're in the policy role, is what criteria should you be using to decide how to respond?
And that's something that training can do. And maybe not something you need to specifically address as a must do, must not do in your behavior code, but there can be ways to nod to that to open up consideration of some of those factors potentially.
Okay, Mr. Dennison.
Yeah.
Too many of us.
Yeah, I do want to say, so there was a recent decision that came out about, policies with respect to how you respond to bullying and whether you followed all the aspects of it, which are also rooted in law that could result in a ministerial duty, which gets plaintiffs' lawyers to money. Anytime you try to script something in a policy or protocol as to exactly how someone's going to respond to a situation where someone can get hurt, you really are opening yourself up to potential exposure. We do have mindset training when we know there's situations where there's likely going to be a physical intervention with students because of the nature of the classrooms, the students there. We require the mindset training, and that is an important component in those contexts. You really, to my mind, you really don't want to be highly scripting those teacher interventions and telling a teacher exactly what to do in one of those situations. I would have and it is case by case, it is situational. And to Dr. Brinkman's point about, the sort of, this is the collateral damage you'd expect. You drive drunk and something happens, someone dies, you're going to get charged with manslaughter, you're going to do whatever. I mean, thinking about when there are fights, things do happen, and fighting is not allowed. And I think students need to know that, when there are fights, there's consequences that can go beyond just the fight, and it does make it a serious thing. So I think that's a good point when we think about fights. But, from a policy standpoint, I'd be very careful about scripting out scenarios. To their point about training, I do think it is important for there to be training. And it's a key area for staff to feel that support because they're putting their lives on the line, their health on the line. Lots of times we have pre-existing injuries with staff, and they're in a position where they don't know what to do because they think they're in an environment where there's going to be potential violence, and they're the ones that are getting called on to intervene. And so that's a real important piece, I think, for staff support. And I will say one other thing. There is a law that actually provides immunity for staff from a criminal standpoint as they respond to these situations, which I think is helpful. I'm glad it's there, which does allow them to come in. It doesn't mean that it's going to stop people from getting sued, people trying to press charges against them for whatever they do in those situations. But whatever we can do to support our staff in terms of training and letting them know that we appreciate that they're stepping into very critical, important situations to keep students safe is important. So I think if we can address that through training, I think it's key.
Don't we have some of that in the ways that we handle children with profound disabilities? Those are
that was the mindset training I was referring to. Yeah.
So this is not, we don't have to build this from whole cloth. There is a certain level of intuition around how to handle physical intervention when young people are not in control of their bodies, whether it's because they are ramped up emotionally or whether it's because of some other condition that they're not under control. So information on that training can be made available to us and to our core. I'm getting some nods.
Yeah, absolutely. Yeah.
Okay, all right, thank you.
And that was a great point about this case about creating ministerial duties. I think a lot of school lawyers around the state read that case and kind of tensed up a bit. The school system involved in that case has asked the Georgia Supreme Court to review it, and our clients have actually filed a brief supporting that because we think it's wrong on law and the facts. But more to the point, really what we're getting at is educator judgment and adult judgment. And I don't know that there is a policy in the world that can really envision or imagine all of the scenarios you could use. There are too many factors. I would never expect an educator to get in between a gunfight. And I don't think the PSC would either. But if it's separating two kindergarten students on the playground, that might be a thing.
Everything in between, right?
Hang on, we've got one more question.
Absolutely. And then we were going to look at a break, so.
So in the same wise, thank you, in the same wise of this conversation, what policies do we have to protect our employers or teachers that do get inside of this fight? I know Attorney Dennison just made a statement about the law protecting them, but what do we do as a school system? Will a parent or if a parent presses charges against a child, or if a parent presses charges against a teacher for interfering in that fight? You jacked my son up, but he was wailing on someone. So we took him off of the person. So now that parent wants to sue or, take that individual to court. Do we fire? Do we rehire? Or is it a case-by-case scenario there? What type of protection do we offer for our employees?
I'll defer to your legal counsel on that, but a lot of districts, they may investigate to see was there fault. And if there was not fault, many districts have what they call indemnification, either policies or practices, where they say, if you do something in course and you are not, even if it was careless, if you were really not maliciously doing it, then we're going to provide legal counsel for you. But I'll defer to your legal counsel as far as exactly how that goes.
Yes, and Mr. Ray was going to weigh on that, and certainly it's a layered, complex situation. So you could have a situation where, okay, based on the context of what this teacher is facing in terms of something with on the DFACS side or on the criminal side, we feel like if we put the teacher right back in the classroom again while this was pending, that could be problematic. It could expose the district. Right. And lots of times that's a real huge challenge to show support for the teacher while you're taking the teacher out of that situation, because you have that exposure. Knowing that line as to when, okay, we think this teacher is safe to return, are we going to wait for a third party? It could be a backed up third party system to tell us what to do. These are really challenging issues in terms of always wanting to do exactly the same thing versus not punishing or demonizing a teacher or damaging their reputation when we've had situations where we know that students, their MO is to falsely accuse people, and they've done it multiple times, and then there's a scenario, and we know there's not really any justification for it. And so I say, well, why would you treat that scenario different than another? Well, that's why you have to, kind of step in and take these case by case. Now, campus police tries to look at things ice cold and say, is there a criminal basis here or not? So they conduct their investigation, and sometimes they will send those materials on to the DA to make the DA make a call, since campus police is our own department. And sometimes they face accusations that you're just beholden to the school district. You're not going to look at it straight up. So many times when it's a particularly serious situation or an injury, or a parent that has really, come in very hot on the matter, they will sometimes send that on to the DA's office to get their official review of that investigative case file to let them make that decision. But it really comes down to those case-by-case situations. And I think it's a challenge for us to show that support for the teachers when these things happen. And I can think of situations where you've had teachers in classrooms where we know the students are going to need to be restrained. We need people to restrain the students. We know that when restraints take place, somebody's going to get hurt, and it may not be perfect. And then those folks are put on a situation where, oh, now we're looking at them criminally, we're looking at them whatever, when they're simply doing their job. And it's really a huge challenge to have support for those staff and know how to have the discretion, scenario by scenario. And I think one thing that's important that we're looking to do is to make sure that in some of our SPED classrooms that we're going to have cameras in all of those classrooms for security purposes. We had that pilot program, and it really helps in a lot of those scenarios to have that footage to look to say, is what happened right or was it wrong? And that can help us instead of it just being people trying to break things down. But we're something we continue to work on, and we struggle with these challenges of supporting staff while also minimizing liability and showing that we do care when these scenarios happen, that we're taking measured responses.
And with that, are y'all ready for a little break? Is that okay with you, Mr. Moss? Sure. Okay, we're about halfway. And so why don't we take, oh, Lord. Let's take 5 minutes. How about that? And during that time, I want you to think about off-campus misconduct and what that looks like. This has been a hot topic at the state board, and how we handle that, and maybe some cases that you've thought of that maybe this has come up. So let's take 5 minutes. It's 3:08. At 3:13 promptly, we will get started. Is that enough time for y'all to stretch your legs? Okay, and get a drink or whatever you need to do. All right.
Get back in your seats. Class is in session.
I don't have a gavel.
Mics are hot.
All right.
That doesn't scare me, Kurt. I know. Check one, check one.
It's like a legal disclaimer. Mics are hot.
We haven't used this yet, but ew, David.
She only said it once in the whole thing. She only said it once.
How dare
She
you?
made a count.
Oh my gosh, that show is so funny. All right, would you like us to get started? You want us to wait a little bit? Okay. We'll get started. All right, and we're off. Here we go. Off-campus misconduct. And we're not going to spend a ton of time on the rest of these discipline slides. We don't want to get mired when we need to get to the really nitty-gritty of the work that you do. But off-campus misconduct requirements has been something that we've been seeing at the state quite a bit. And they've been a bit active sending these cases back down to school districts. So we want to make sure what you understand what they're looking for. Essentially, jurisdiction, we're going to talk about a little bit more about jurisdiction, but jurisdiction has very specific parameters. We're talking about school districts. You are not, and thank goodness, you are not in charge of everything a student does in their home. And just, woo, absolutely, let's hear it. Because we don't want to be in charge of that, and I can tell you your principals don't want to be in charge of that either, even though families really would like them to be. They are not. So most of what happens off campus, you're not in control over. But when a student commits a felony or what could be a felony if they were an adult, that is something you can discipline for. That is one of those situations where we can reach that arm out. We may choose not to, but we can reach that arm out and pull that behavior and discipline a student for it. Essentially, you have to be able to show in the disciplinary hearing that they were arrested or they were charged or they were actually convicted or adjudicated to have committed a felony or what would be a felony. And you have to show that the student's presence at school is going to be a danger or disrupts the educational process. This is really, again, all about training, but I want you all to have some context for what the state is looking for when these come to their door. They want to see that you have considered these factors and these factors are present. A question I get a lot is, what happens if we find a student, let's say he's been charged with rape or murder? We've had that too. And we discipline that student by permanently expelling them based on that off-campus behavior violation. But they weren't found guilty yet. What if later they're found to be guilty of a misdemeanor or they pled down or something like that? The law does not require you to go back and, quote, fix it. You don't have to do that. Most of our clients do not contemplate that when they deal with off-campus felonies. It is what it is at the time that you review it, and we're moving on. There have been situations, and your attorney can help you with this, where they've thought about considering if a student gets completely exonerated, not just I negotiated a plea because my mom has lots of money and I can get a good lawyer to negotiate a plea for me, or I'm friends with the DA and so they knock down the charges. If they get completely exonerated, I have had clients do a very, very narrow exception that says you can apply to the superintendent, and if the superintendent wants to let you back, and if it's completely exonerated, then maybe we'll consider letting you back. But most of my clients do not do that. They just say it is what it is at the time that it is.
Yeah, I am happy to chip in on this one. So for the board members that do remember, this was something that was near and dear to the heart of Julie Wade. Not everybody was here when Julie Wade was here. And the last policy, one of the last policy changes we made was to address this scenario. And we have turned it over to a process where even if it's not this extreme exoneration, if it charges change, whatever happens, it changes in the criminal context, that it can be presented back to you for a new action. So that's in our policy, and we have actually done that, over the last couple of years with some scenarios that came up with DF. So our policy does allow for that.
Great. So that is something that gets asked a lot, but this is the basis for why you can even discipline the student in the first place, and these are the factors you have to consider. Okay, let's talk about jurisdiction, because I get this question a ton as well. That arm we're talking about, when can we stick that arm out into the community? Most school districts will exercise jurisdiction and can exercise jurisdiction in the following scenarios. So the land and improvements which constitute the school, basically within your property bounds. I've had to bring property line maps to the state board to show them this happened on our campus, okay? So where the property, within the property lines. Any other property or building, including school bus stops, where located, or where you're having school-sponsored or school-sanctioned activities going on. So if you lease a facility where you have prom or homecoming, jurisdiction could be asserted there. If you have a fight at a bus stop, and that gets real funny because what's a bus stop? When is a bus stop? That's a whole, we have that, that's a more of a staff conversation. But things that happen at bus stops, we have had weapons and things like that show up at bus stops. Yes, that's something you can touch. A bus or vehicle used in connection with a school function. Let's say we're on our way to a sporting event and we have chartered a bus and a kid's getting a fight. Can we discipline for that? Yes, you absolutely could discipline for that. And then, of course, en route from school before reaching home. So the state board has said if a student, let's say a student is, now this is all can exercise, not must, because there are times where we're like, we don't want to be involved in that. But if a student is walking home and they have not reached home yet, and they pull a gun on another student as they're walking home, and let's forget the felony thing, because you might be able to get it under that and not even worry about this en route from school. Or they get in a fist fight. Theoretically, the state board has upheld school districts exerting their jurisdiction in those situations. There are a lot of times, though, when schools say, we really don't want to be the police officer for that. It has to be super serious before we would be interested in that. There have been a few times where clients have said, it's so bad, it was such a bad situation that we want to jump in on that. And you can, but that doesn't mean you have to. These are all can. And so most school districts have a pattern and a practice of when they exert. But this is generally the bounds of the law that we're talking about here. All right, we're going to do a few scenarios, and you're going to give me yes jurisdiction, no jurisdiction. Okay, and we can talk about it. And some of them are tricky. While walking from the bus to their apartment, 2 students jump a third one and rob him. Haven't returned home yet. Yes, that's the correct answer. Yes, you can. Do you want to? Is a whole other question. Maybe you don't.
Well, like, can you?
Can you? You could, because they are walking home from the bus stop, they have not returned home yet, and they attack another student before they get home. Yes, you could discipline for that. Do you want to? Maybe not, but you could. Male and female student leave campus, go across the street and park. Upon return, the female says that she was sexually assaulted by the male. Can you exert discipline for that?
Upon return to the school or upon return to the park?
So upon return, when she returns to the school,
in the middle of the day.
yeah, they're leaving campus, going somewhere private, bad things happen, and they come back, and when she comes back, she says, bad things happened to me sexually. This was a bad situation.
An unexcused absence. This is the unexcused departure.
Yes, they're probably going to get in trouble for skipping regardless, but
Yeah, okay.
so this could go a couple of ways. I see nodding. This could go a couple of ways. Number one, it could be this en route from school. You left school and you didn't go home and then you came back. So yes, you could do. It could also be a felony, right? As could the first one, maybe if it was a bad enough jump. So yeah, there's a couple different ways that you can go after that. And then of course your Title IX procedures could kick in at that situation, depending on exactly the facts of it. But theoretically, based on this little tiny blurb, I'd say yes, you have good argument to have jurisdiction over that case. Student is suspended, they come on campus anyway, and they start a fight. Which happens.
They're not even supposed to be there.
Yes, absolutely jurisdiction there. Because anytime it happens on your boundaries, whether they're supposed to be there, whether it's midnight, whatever, that's your property. They can get in trouble for that. That is jurisdiction, even though they're already suspended. So it looks like they're going to be suspended more, probably.
They like to do that too.
They do, because, I got unfinished business. And as one seasoned principal told me, that student is not a student here. That student attends here. So a lot of students, they attend there and they want to go back to their place of business or whatever that place is to them, and they want to have their say. It's the weekend, school's closed, student comes in and shoots his gun for target practice. Or steals the TVs, or whatever they like, or runs around and toilet papers. I mean, that would be the least of our concerns, right? Yes, absolutely, they're on campus. That's an easy one. You see on the news one of your students has been arrested for murder. Is it a felony? If it's a felony, which murder is, all types of murder, then you have a choice if you want
And the
to.
student has in fact been arrested. It's not just
Right.
suspected. They've been arrested.
Would it be safe for that student to return to your campus as a alleged murderer? No, probably not. Is it something that you could consider as a district disciplining them for? Yes. Yes, you could, because it's an off-campus misconduct. And we're going back, now I'm really messing it up. We're going back to this, right? The off-campus misconduct. It's a felony. They've been arrested, and his presence at school or her presence at school would be a danger. So you've met those qualifications. You could. Do you have to? No, you don't have to, but you could. Overnight field trip, students have a party with alcohol in the hotel. Tale as old as time. You actually can do it.
Yes, you can.
School-sponsored activity. If they are at a school-sponsored activity, you can. Do you want to is a different conversation, but you can. But, this is a very common scenario, okay? Very common. At home on social media, student A gets a message from student B telling her she should kill herself and will be jumped at school the next day. Now, this is talking about something we actually haven't talked about yet.
Yeah, but then they just changed that, didn't they?
Everything's changing.
General Assembly, we can't touch this now.
Well, with a situation like this, there's potential for felony. As it stands currently, you've got cyberbullying as well, right? So cyberbullying is something that you could lean on potentially. So this one's a maybe.
A threshold of harm. No, it said it had to originate.
Yes, it would have to originate. It is in the process of changing, so this one is tricky. It would depend on the facts. It would depend on when it happened, because which version of the law, right? It would also depend on whether or not we could find a felony in this situation. So this is a maybe.
We'd go for it for sure, because when they say,
Right.
I'm going to jump you at school, then you're threatening the person's access to school, so we'd err on the side of
That's right.
juris-
I think most
jurisdiction.
districts would in this. I think that is a very common response that you would see.
Kaczmar.
Sorry, we're supposed to wait till you're done. So what if there's a situation where you see an assault and somebody is unconscious, the DA hasn't decided how they're going to charge yet, but on the news, your student was in a gang fight,
Yeah.
and you don't want that student coming back to school the next day because you're afraid of a ruckus, but you don't know if it's a felony or not.
If they've been arrested, so there is part, let me go back again. There is part of this that says, and it's not in here, it could be or is a felony. There is actually a part of the law that says could be. There
We
have
have some
been,
discretion.
yes, there have been, as long as they can just be arrested, that's enough, right? If we can verify they were arrested, that's good
Even if
enough.
they're arrested for a misdemeanor for right now.
But we think it
could
could
have been
be.
felonious conduct.
Or they haven't even been arrested yet. That's a situation. Now, is that gray? And are you going to have a little bit of a legal fight on your hands? Possibly. But at some point, clients will say to me, let's let the state board tell us we have to put that kid back in school because this kid is scary. So that may be a situation where you get with your legal team, we talk about the risks, it's a gray area, let's roll the dice, right? That might be a business decision whether or not you go for it. And a lot of times my clients will say, I can't in good conscience put this kid back in school. We're gonna go for it, we'll make our best argument. If he gets put back, he gets put back, but I can't let him come back to school. So we've had that situation. Student standing in front yard before school shoots at a bus with a BB. Probably not gonna be jurisdiction. But because they're still at home, they're not really our kid yet, they're not at the bus stop, they're at home, and it's probably not gonna be a felony to shoot a BB. However, does that mean we're not gonna call and report this to the police? and talk to the family and do other things. No, it doesn't mean that. We can still do things, but this may not be standing alone something we can discipline for.
I'm getting a frown from our.
Oh, we'd go for that one. Sure. If it's his school that's on the bus, his students on the bus, like his classmates or the bus he rides, definitely for sure. I feel like that's, you really are going after the school setting when you're shooting at the bus. It's like your bus or something.
We can
I don't
just
know.
say he's a potential threat the next day because
Yeah.
everybody on the bus is going to pummel him.
Yeah, we would go with something on that one, I
And
think.
what you would have to overcome with that one is, and this is where the fight would come in, right? And that's okay. We love a fight. Everybody loves a good fight. But where the fight would come in is the parents would say, he was still at my house. He was still under my jurisdiction.
Hopefully the parent would say, yeah, you're right. He shouldn't have done that. He's he's in
That's
trouble.
The dream. The dream is that the parents come in and say, you're right, the safety is important. But it doesn't always happen that way. We would like it to. So that would be one where you may just make a business decision that we have a straight face, we think, legal argument, and we might go for it. Other districts would say that one's too far afield, we're not going to touch it. It just depends on the district.
Dr. Howard Hall.
I was thinking about a countersuit. Something similar happened to me as a kid. Back during the time when I grew up, dogs would just run rampant.
Yep.
So if you walking from the bus stop and a dog attacks you and bites the student, it's jurisdictions, for the school district. But don't we have the right to countersue as a school district if we knew who the owner of that dog was that was running rapid in the neighborhood?
If a student was attacked, let's say a student was attacked at school because there was an animal that had gotten in, we absolutely would then look to the owner of the dog and say, if we get in trouble, we're going to look to your homeowner's insurance or something to subrogate or to back us up. Yes, absolutely. That would be something that we would ask about. That's a good question. Look at you guys. All right, so this is a real quick aside, withdrawal. That is I love this image. That is the instinct of every parent whose child gets in trouble. We take a hard stand. Now, not every district does, but our team tends to, so forgive me if y'all disagree, and that's okay. We take a hard stand and say, if you have a disciplinary action that is pending, we're not letting you withdraw. You can fill out the paperwork and we'll date it for when we've had your hearing, but we are not letting you withdraw.
Yeah, this is one I keep butting in, but the new Omnibus Safety Act that just got passed, I think this impacts like what you have to do for transferring students in terms of how you handle it and report it.
Yes, absolutely, and it should. One of the things that came to light with Appalachia was, did the school district who had that child, not for very long, have the right information? And the legislature is trying to solve for that. I will say this, there's two reasons not to let students withdraw before you have the hearing. One is because it's the right thing to do. Have the hearing, make sure that that student can't go to another school and hurt somebody at that school district, because that school district is not going to have jurisdiction to deal with that issue likely. So if you let the student leave without discipline, they're just going to go to another school and do something there. The other thing is, even if they promise not to come back, you may lose your window, and then that student will just turn around and come back. And there's nothing you can do about it because you've lost your window to discipline, and now they're back. We can't have an agreement that's enforceable that a student is not going to come back and re-enroll in this type of situation. So it's not really something you can negotiate out. So they have a right to go to school unless there is something specific that keeps them from doing that. And the way to do that is to go through the hearing process. So anyway, we always tell people, and you might get complaints from parents about this, but just know if we're not letting someone withdraw, there's a reason for that. Special education, I don't want to spend a ton of time on this because frankly, we could spend all of the time on this, but just remember that there are specific rules. I think you all know this, but just a refresher, specific rules with students with disabilities. There are very, very different outcomes potentially for students with disabilities, and it is not something the public understands. I think if they did, they would be very surprised to learn that two students can get in a fight and one student is special education, one student is not, and one of those students may not get disciplined if is found to be a manifestation of their disability, and the other student could get significant discipline. So remember that there are special rules. Y'all are gonna have this slide deck. We'll go over them here with you, but just remember that those are things we have to consider. They're not optional, they're federal law. We don't really have a choice about that. Also, you may see in appeals when a parent says, "Oh, contraire, my child is disabled, so you cannot discipline them." The reality of the situation is, if the parent, usually what that is a situation where a student has gotten in trouble and all of a sudden the parent says, "You know what might be helpful in this situation is if I trigger an evaluation for my child for, bless you, for special education." Yes, we'll still do that evaluation, but no, it's not going to get you out of the discipline to come in the 11th hour and say, "Oh, wait. Yes, I know he beat up a teacher, but actually he's disabled. I just didn't tell you before now, but now I'm telling you." That's not going to be good enough. However, if we have failed with child find requirements, then that may be something. But I would think by the time it comes to you all, that's already been reviewed by your very able legal counsel. They've already looked at that and determined whether or not we were in a child find situation and we should have known that that student had disability.
Well, and in addition, y'all don't determine whether our kids are disabled as a board. You don't determine whether or not behavior is a manifestation of a disability. Your job is to determine discipline, and that's it. So please, keep those on parallel tracks where never the twain shall meet. You may have a discipline appeal of a disabled child that comes to you, and you may disagree with the manifestation and determination that may have been made by the school team that's working directly with the child, but that's not your role. Your role is just to determine discipline.
That's right. And what Nina's referring to, and you probably are familiar with this, manifestation determinations, but essentially, if it is found that a student's behavior is a manifestation of their disability, then you are limited in what you can do. Now, you have that 10 free days, right, that we can treat them the same as any other student. But beyond that, if it is found to be a manifestation, then no discipline is going to be available to you for that behavior.
There are a few narrow exceptions,
Yes,
like
there are.
weapons and drugs and serious bodily injury, but hopefully those are few and far between.
Right. And even if it is not a manifestation, we still are going to have some restrictions on what we can do. For instance, and I always have to remind boards this when we're dealing with discipline, if a student is a special education student, we can never permanently expel them. Not really. We can say that they are permanently expelled, but the reality is for the remainder of their educational career, we are going to owe them some level of services. It's something we call reduced FAPE, or free and appropriate public education. That is at a lower level than they might get in the regular school setting, but it is still going to be some level of education that will enable them to make some sort of progress and graduate. So we will still, now will it look like what it might look like your alternative school? It might look like services in prison. That is a thing. It could look like a home visit from a tutor or a virtual visit from a tutor, but it is not going to look like them being back in the school generally, unless that is the only place they can get reduced FAPE, which is very unusual. So you can really never permanently expel a student with a disability. All right, so let's talk about just a few things that we see in governance that helps boards with some of these things we're talking about. We're sort of laying the stage, but what about, to Dr. Watts' point, let's pull this up to board, what boards actually are doing the majority of their time. We've talked about understanding some of the more interesting scenarios that we're seeing pop a bit more at the board level in appeals, but what can you all do to make things easier to streamline your process? And let's talk about why we would even care to streamline discipline. Every time you have a disciplinary hearing, there is a legal risk of an appeal, potentially going all the way up to the Georgia Supreme Court, potentially also resulting in a federal claim for a violation of due process, okay? So we don't want to do more hearings than we have to. We always want to limit the number of hearings. There's also a cost of time. Each disciplinary hearing takes a ton of administrative time. They have to prep for it. you have the actual hearing, you have the appeal and the prep for that. And you all know, anybody that stands at this podium, for every hour they talk to you or 5 minutes they talk to you or in the executive session room, that's like many hours of preparation on their part, right? Because you guys are the rock stars and they want to impress you. So, believe it or not, they do. So in that situation, you are burning so many resources on each one of these hearings. That's okay, because discipline that's serious should be taken seriously, and students are entitled to their hearings. But if you don't have to have them, if you're having more hearings than you need to, that's something to think about. I'm not saying you do. It's just something to think about as you think about what can we do to streamline the situation. So here's some common streamlines that we see districts taking. You may consider, maybe you've already done these things, and you can give yourself an attaboy for that or attagirl for that. Common streamlines, making sure you don't grant more appeals than you have to. Stick tight to the law, and your lawyers can help you with that. Making sure we're not giving people more appeals than we have to, because again, every single one of those is an opportunity for time, fees, those sort of things. More litigation. Tight control on hearings. Again, not having more hearings than you have to. If you use tribunals, which means a 3-person panel, and I don't know if y'all do or not, I could see that there was an option for that, but if you do or you consider that, you may want to consider not doing that, because when you have 3 people, that's a lot more people than 1 person having to be pulled from or paying them if they're retired educators, right? So that could be something that could be, and I will tell you, the people that have to set up those panels, that's a lot of work trying to get those people set up.
Of Congress.
If you have a tribunal. If you don't have a tribunal, that's great. But if you do, you may want to consider streamlining. Look, there's benefits to having tribunals too. You have more people listening and that sort of thing. But it is a lot of work. A lot of my clients have moved away from that because it is too much work and they just couldn't maintain that. And with budgets getting tighter and tighter and tighter, every penny was counting. If you have an oral argument provision, considering not doing that. You don't have to.
At the appellate level.
For you all. There is no requirement that you let anyone come and talk to you. That is something that you don't have to do. So if you are having oral arguments from students, then, or from their families, you do not have to do that. And it can cause some legal problems, because an argument could be made that you are listening to what's said in the argument and you are not really considering the record, which is what the statutes require you only to consider. Okay, so that's just a thought. Honestly, it takes time, right? It takes time out of everyone's day.
Yeah, we're on board with your approach.
Okay, gotcha. That's right. Training, I've said it. I'll keep saying it. Training, 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 training. The more training you do of your hearing officers and your staff to make sure that they know what this is, and training for yourself on any issues that are causing confusion, that is going to make things easier. And I always say the nitpicky review of your code of conduct. Your code of conduct is a living document. Every few years, this is my recommendation, people can disagree. Every few years, I think you got to take that code of conduct and you got to see, is it been Frankenstein so much, because we added here and taken here and rewritten that, blah, blah, blah. Every few years, do we need to just gut it and consider the environment and legal changes that have happened and really start over and make it? And now you are required to consider parent input and stakeholder input into your code of conduct. You may want to see what they think of it. You have a regulation and a policy. Some of my clients have said, too complicated, we'll just put it in one thing. Whatever works for you all, but I do encourage you every few years to consider whether, has this thing gotten a little unwieldy? Do we need to go back to the drawing board? Please don't do that in April for a September start or an August start. If you want to gut your behavior code, I'd start probably December and start working on that. It takes a lot of time for staff to rewrite that.
And this periodic gutting of your code of conduct, whether it be an administrative regulation or board policy, I think a periodic review and potential gutting of your policies is a good idea also.
Yes.
You don't need to review every policy every year, but have them on like a 5-year cycle or something, or a
Great.
4-year cycle, I think. That's awesome. Because the laws
star.
change,
Yep.
and policies get Frankensteined also, and they become unreflective of the will of the board.
Yep.
And ultimately, policymaking is one of your very big jobs. And that's where you should be spending a lot of your time.
Yeah, gold star for having a policy review schedule. That's huge. And you'd be surprised how few districts have that. So you're really ahead of the curve on that. That's awesome. All right, we're at the end of the student discipline part, barreling towards the end of this program. We've got about, I'd say, 45-ish minutes left, and we're going to hit on governance reminders. These are refreshers. I am not, almost every one of you is a veteran, so for most of you, this is a refresher. I know, you're like, not me, that's okay. You've been drinking from the fire hose, I'm sure. It's a lot, but for you, maybe not a big refresher, but maybe a little bit. And for the rest of you, you're like, oh, we've heard this before, but it's good to hear it again, because you can so easily slip into bad habits as board members. And I will also say that I've never met a veteran board member who I didn't have to call and say very nicely, I think you're in the weeds on this. I think we gotta get out of the weeds. One of my clients has a stuffed fish that they hurl at each other when they're in, I don't recommend violence, but symbols of,
It's a squishy fish.
it's a squishy, they call it a dory, and they'll throw it at each other. That's right. Get yourself a squishy, cute animal and toss it at each other if you think somebody's getting in the weeds. But policing yourself is important because your superintendent has a really difficult job, and we need to let her do that job. That's right. So anything else about discipline before we move on to governance? Great. Okay.
Oh, I'm sorry.
Go ahead.
And I had written a note. So tell me about any district that has a fighting policy.
Okay. Excuse me. So some of our districts delineate physical offenses they have a bucket of physical offenses, and then they delineate them out. So they may have fighting, which is defined as mutual combat. They may have battery, which is generally going to be like a jump or an unprovoked attack of some sort. They have assault, where a student is in fear of getting hit, doesn't actually get hit, but still like the physical threat, maybe not a verbal threat, but like a physical threat. They also may put threats under that. They also may put horseplay under that. I've seen some districts say, we need something that isn't fighting, but isn't this and isn't, picking and...
But it's still physical and it's disruptive and yada, yada, yada.
We need something that really speaks to what that is, especially at certain levels, right? Educational levels.
And some of them have an offense for group fighting, where it's
Right.
more than 2 people and it's just a big old brawl that
Right.
takes over the school, and that happens.
Right.
These don't necessarily live in policy. They may live in the code of conduct as an administrative regulation, but that's not uncommon.
Yep. So you can do that if you feel that you need to distinguish it. You could make a bucket and then pull those things out. One thing when my clients are considering when it's gut time for their code of conduct, they will benchmark a few districts that they think they'll pull a few codes of conduct that they think are really interesting and good, and they may crib off of those and kind of make it their own. That's one way, and I would recommend if you do that, stay in Georgia, because Georgia has very specific rules about what has to be in your code of conduct. Generally, you have a lot of discretion on what your discipline is, unless it's certain offenses like guns, a couple other offenses. There's some bullying requirements. There's requirements for physical offenses against school employees. But generally, you have a lot of discretion on what the ranges of discipline are, but there are certain things that have to be contemplated in your code of conduct.
Yes, Ms. Grabowski.
Unfortunately, we've also had parents get into fights. Can we do anything about parents?
Sure. I have a whole training that I do called dealing with disruptive individuals.
The criminal trespass warning is a beautiful thing.
It is. I have become the patron saint of that topic in our office. I really kind of enjoy it. It's really fun. And I will tell you, if you ever want like hero worship on the highest level, go into a school and do that training and give them practical, real world ways they deal with disruptive people, custody situations, the wild and the woolly. I have always felt like they're going to carry me out on their shoulders. They're so excited to hear it. There is lots you can do to control a parent being physically threatening or violent on a school campus. And there are some artful ways to also control over communication that becomes disruptive. And we've kind of have a toolkit that we use for that. And it tends to work, although you have to remember, for those of you that are educators, the extinction behavior. When you start putting restrictions on people, they will have what I call the crocodile death roll, where they will, they don't want to be constrained.
I think the BCBAs call it the extinction burst.
That's right, the extinction burst. I call it crocodile death roll, where they just do, so it will get a little bit worse before it gets better. But there are things that you can do.
But how do you handle on a policy?
I'm sorry?
How would we handle that on a policy?
Yep. So there are specific laws and policy requirements that you can put to visitors for school and for custody that set your staff up to use that toolkit effectively. So you can be very clear about your expectations for visitors, your custody requirements, those sort of things, and that provides the base. You as the board provide the base to allow your staff to do what they need to do in those situations.
I would love to have access and more information on your toolkit.
Sure.
Because we do have what I feel like in some cases an over abuse of staff and having to
absolutely
respond to people
absolutely
daily in some cases.
Yep.
And it is impossible to do that. And it is creating an issue with teachers that I've had teachers to quit.
Yeah,
Sure, absolutely. And
I would
sometimes
too.
parents
Yes.
can get abusive and threatening over email.
Yes.
And educators don't sign up for that kind of
Yes,
thing.
so if you have, we have not mastered how to give that guidance
Okay.
yet, so I would love to have
We can
access
help
to that
you with that.
information.
Yeah,
Dr. Hoskins
absolutely.
Brown.
Thank you. I'm intrigued in hearing about these trainings that are available. I know they're directed to the operational side, but I think they'd be really informative for the governance side. And we've been really, really thirsty for new content. And I think learning about that over communication process, if it's something that we could also experience for credit, it would be helpful for us, because then we know how to receive communications, because of where we sit, we are deputized to pass it forward. So we become a tool in the over communication, because we can't ignore it,
Right.
And some of it may be very valid, some of it may be just, trying to get a lot of attention, but we become tools in that. And if we could participate in that kind of training, it would allow us to learn how to diffuse and be more supportive of our staff.
Absolutely.
Okay.
And
Dr.
look at the
Howard Hall.
placemat. Oh, I'm sorry, go ahead.
Dr. Howard Hall.
Yes.
With the primary grades, what can you tell us regarding policy as it pertains to biters? I had a student that bit. He
specific.
I was a biter as a
He's
kid,
a biter.
believe it
He
or
just
not.
bit kids.
I love to bite.
Policy.
I did.
So,
You didn't know what you were getting with us, did
Right.
you?
with the biting, and that's pre-K, kindergarten with policy, breaking skin. I mean, to what extent?
So that's going to be a code of conduct issue. That's student misbehavior, right? And kids know they can't bite usually.
Unless you're dealing with a special education
Right.
student, and sometimes
And
your
they're seeking
autistic
sensory
student.
input, or
Right.
that's how they communicate.
It can be a sensory thing. It can also be form of communication for your autistic students who are nonverbal. So you have to deal with those things more proactively through FBAs and BIPs, and potentially some other sensory opportunities for those students. But yes, and I will tell you, we haven't said the words workers' comp, but
Right.
that could be a workers' comp
happens.
issue. If someone gets bit severely enough, there's a workers' comp issue. And you're going to be on the hook potentially for their medical
Yeah,
treatment.
I mean, workers' comp is essentially a strict liability.
Yeah.
So have you run up against any school districts that have policies around gang activity?
Yes. Yes.
Please tell us
It
about
was
it.
all the rage back in the late 90s, early 2000s. Gang activity was sort of a hot topic. It goes, discipline fads come and go. Sometimes everyone's worried about bullying. Sometimes it's vaping. Sometimes, it just comes and goes. But the gang issue has come and gone into vogue, for lack of a better term. Yes, we've had districts with gang policies. They do gang trainings. We've litigated the gang issue. There's a few different ways. That's where I think a lot of school districts have turned to the group fight thing to sort of address some of that. It is and can be very difficult to prove involvement in a gang. Now, the definition of criminal street gang in Georgia is very, very broad, but courts have been reluctant to apply that in the educational setting absent some very clear evidence that they are in fact involved in the gang. And being in a gang is not necessarily illegal, it's the gang activity. So a lot of districts have a nod to gang activity, but they then focus most of their attention and time in the behaviors that come from the gang activity, if that makes sense.
But depending on how big of an issue it is for your community, I mean, I have a client where part of their code of conduct is gang activity. It's not just fighting.
Yeah.
It's signs, it's clothing, it's
Graffiti.
insignia, it's all of it. So if that is an issue in your community that is worth
Yep.
your attention, it can be done.
Yeah, you just have to invest some time in the training because if you are disciplining kids for this, your administrators are going to be asked under oath, how did you know it was gang activity? And they're going to have, either them or your campus officer is going to have to explain the training that they've received to identify gang activity.
Dr. Hoskins-Brown.
I just want to ask our team, we do have that training. Doesn't our chief have training on insignia and that sort of information?
And he's brought in special experts on that to train the force. Mhm.
So I don't think that we experience it on our side. And I don't know how much teachers get that versus the resource officers in the campus police. We might need to expand the individuals who get that exposure.
And how you notice students is important too. So the wording in your code of conduct so that students are on notice of what is not allowed, that's important as well.
Yeah. Because some of the local gang imagery is very subtle.
Yeah.
So as to fall
Absolutely.
below
They're
the
smart.
radar of
And it changes
policy.
over time.
Yeah.
Yeah,
Thank you.
and so you have to have updates to that training too. It can't just be a one and done kind of training.
I would love it if you would share with us some of the policies that
Certainly.
you've seen around that.
Absolutely. Yep, we can do that. We can give you, and if you're interested in gutting, we can give you a couple of codes of conduct.
The code of conduct, she meant gutting the code of conduct.
Yeah, not gutting people or gangs or anything like that. Gutting code of conduct and revisiting some of these topics. We have ones that we know are legally compliant. You want to be careful to just, I mean, obviously you have attorneys that are going to review that, but you want to be careful just pulling one out of the ether and saying, I like this one, because it may not have what's required under the law.
Just for context, 2 years ago, we did reset our entire code of conduct effectively in terms of discipline with a matrix. So what you see in the center of the code of conduct is only 2 years old, and that was because we were getting into trouble in terms of consistency of discipline, and we were notified that certain charges were being overused and could be used in a discriminatory manner. So we reset it based on Lincoln County's matrix, which was recommended by the state in order to address those concerns. So we modeled it after that, but it was developed 2 years ago. So while the policy remains largely the same, the operational piece is only 2 years old.
All right, so we're going to move on, if that's okay with you guys, and start talking about the governance aspects, which is, everything we've been talking about is governance, but we're going to do the brush up. And we have just a little bit of time, I think plenty of time to talk about this. You all, as a reminder, your proper role. We've talked about this, think tank, nobody can do it but you, and even though you are an elected official and you are accountable to the citizens that voted you in. You cannot prioritize those votes over the needs of students. Your primary function is to be concerned about the students, not about reelection.
And all students.
All students, not just the ones in your post or your district. They have to be, you have to consider all of them. And we have a law, and we can show that in just a second. I always tell school board members two things. If you're considering whether you don't want to be a school board member anymore, you're probably close to not wanting to be a school board member anymore. Because if it's even entering your mind. Now, I mean, like really considering, not just going on and being like, why do I do this? But like really considering it. And also, if what you are really worried about with this role is reelection, you're probably getting to a point where you're getting to burnout, right? Because reelection really should not be the focus. What should get you to this table every day is the kids and the staff and the people that you're serving in your community. And that's hard. Sometimes when you're talking about buses and policies and you lose sight of that. But remembering that as a board member, you truly do something good every day for someone. How many people can say that in their lives? But if you lose focus of that, just give yourself some grace. All right. Here are some red flags. And we're going to go, remember we talked about things that if you want to make your life really terrible as a board member, here's what you should do. You should absolutely forget your entire role and not care what your role is and just do whatever you want and go to schools and tell staff what to do and don't loop in your superintendent and just forget about what your role is completely. And also, you should meet with those special interest groups and you should make them promises about how you're going to vote. And while you're at it, meet with some vendors and make them some promises too, because, you know, jail is lovely this time of year. And those are things that board members really do. I'm not saying y'all do any of these things, but those are the things that if you get complacent as board members, it is a path of gold. It's easy to get there. You can slip into it. So reminding yourself regularly, and this is one of your moments to do that, and going and reading your code of ethics. If you haven't read the code of ethics in the last few months, read your code of ethics. It is such a mindset refresh, and it's so good for you to do. Anything you want to add to that? Okay.
You got it.
All right. One of the most important aspects of being a board member is remembering that you are on the balcony. Now,
We
doesn't
love this metaphor.
We love this. And doesn't this person on the balcony, don't they look peaceful? Doesn't it look nice I mean, the party looks fun. Yes, yes. But the balcony is peaceful. The balcony is where you do the big thinking. The balcony is where you figure out, what do we want for our district? But your superintendent and your staff, they're on the dance floor. They're at the party. They're following through with your big ideas. They're doing the how. So you tell Dr. Watts what you want to see through policy, through conversation, through her evaluation, all the things, and then she goes and puts that into motion. That's the operational side of the house. Do you think, y'all tell me, your constituents understand your role? Do they think that you can decide who the football coach is at a local high school?
They think we're the DJ.
Not only are you on the dance floor, but you are an integral part.
Determining the song.
That's right. You are raving it up down there, right? That is one of the biggest challenges I think board members have, especially new board members, because very recently, and for some of you all, you've been reelected, you have people that feel like, oh, I put you in the office, so now all the things that I would like you to do, you can do those things. And we can get extra tater tots at the lunch, and you're going to make sure we get new band uniforms, and all of those things are going to get done. And it is really difficult to explain to them that's not my role. But you have to keep reminding them that's not my role. I do not handle the day-to-day operations of the district. But you have and it may be disappointing when you first get on the board that, oh, I don't get to do, okay, I thought I was going to get to do that stuff. I don't get to do that stuff. But what you do get to do that is invaluable is you are a connector. You put them in touch with the right people that can help them. That is think of how big your school district is. It's huge. People don't know who to call to get help. You can help them with that. So that's something you can do for them that really nobody else is going to be able to do for them, but you are not going to be able to fix their problem for them. And if you let them think you are, woe is you, because they are going to drive you absolutely bonkers, because nothing is worse than, what is it, the Dante's version of hell is you walk into a room and everything's blowing up and you can't do anything about it. That would be what it's like, because you really cannot do anything about it. That's the superintendent's job. Anything else about the?
I think that's it.
Okay. All right, here are the actual duties of the board, and this is not nothing. We spent a lot of time telling you what you shouldn't be doing, but you have so many jobs. You're a liaison. You're doing the policies. Ding, 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 that is huge. Those are the laws of the school district. That's a gigantic thing. You're evaluating the superintendent. You're getting the strategic plan going. You're establishing those financial priorities. You're a good steward of taxpayer money. Finite resources. We can't just spend, like sailors. You're the decision maker for student discipline appeals, employee terminations. You have a lot of important roles. Don't try to usurp, don't borrow trouble from Dr. Watts's bucket. She's got that under control. That's her job.
And there are people that get good money to do this work on the ground. Y'all do not get paid enough to take on these problems.
No school board member does. No, not even a little bit. I mean, it's like 2 cents on the dollar if you work it out.
It is
right?
well
It's
below
nothing.
minimum wage.
Well below minimum wage. I mean, every day of your life as a school board member, you can be at something. So you don't need to borrow that trouble. And look, every board member does it. I don't care if you've been a board member for 20 years or 20 minutes. Every board member gets sucked into that. And you kind of have to remind yourself, oh no, I'm in the weeds. I got to get myself out of this.
And this no surprises thing, I really, really want to emphasize that. This is not to say that your board meetings are, kabuki theater where everything's already decided and there isn't meaningful discussion. The public has, you owe it to the public to see the decision-making process, right? You're working for them at the end of the day. But please don't drop a bomb and I'm not even going to use that metaphor, never mind.
I already think you're violent, so.
That's true. No, I was going to go further, but
Okay,
I'll
sorry.
stop myself there.
Yes,
Now y'all want to know what I was going to say, don't you? I'm not going to. I'm not going to. I'll do it off. I'll do it off camera. Every one of you ran for this post because you care deeply and have strong convictions, and you need to stay true to those strong convictions and do what you believe is the right thing to do as an elected official. And reasonable people can disagree, and I bet y'all disagree sometimes. Am I right? Okay. So you can disagree and not, without being disagreeable. I love that phrase. You can disagree, but give your folks, give your colleagues the respect of a heads up. Y'all know where I stand on this. I've got to speak my piece, and I've got to do what I think is right, but I don't want anybody to be surprised by that. Respect each other enough to share that kind of information. Respect your superintendent enough as well. So she knows, here's what I'm getting into. If she thinks it's important enough to push it forward, she's going to push it forward, but let her know what the landscape looks like.
Okay, so we've already covered this, but it bears repeating. Don't get yourself into the chain of command. Let that process work through the operational side of the house. Now, I don't know what your operating agreement is with Dr. Watts, if she gives you access to certain cabinet members or whatever, but whatever she has laid out for you as the communication path, that's the path that you have to follow. But again, you are connecting. That is a huge win for somebody that's coming to you. You're helping them access the answer, although you are not giving them the answer. And of course, remember, you're one board member. You're one vote. So if you are out in the community and people ask you your opinion on things and you kind of get the sense they're trying to paint you into a corner, always make sure, look, I'm just one vote. I'm just one board member. I'm one opinion. I don't know where this is going to go. I can't give you an answer of what the board is going to do because I'm only one person. And of course, if you disagree with a vote of the board, you have rights as an individual. You can express yourself. But what you need to do, and you can certainly explain your vote, but your code of ethics requires that once a vote of the board has been taken, and it is where it is, we need to move forward. That doesn't mean that you can't say, I didn't agree with it, but I'm moving forward. Here's why I voted against it, but hey, I'm a board member. I will do the will of the board. Here we go. One team. Let's get it done. There is a fine line between explaining yourself and undermining your fellow board members. So just remember that you can explain yourself, but you need to move on quickly from that issue.
And one thing that I have seen boards get really, really, really bogged down in is litigating old fights.
Yeah.
Everyone is going to be on the losing side of a vote eventually. But as a body, not one of you has any power. You only have power as a body. And once the body has made a decision, it's time to move on and get the best out of that decision for kids as possible.
And it really helps to assume goodwill of your fellow board members. If you find opportunity to get to know each other on a personal level, that helps a lot. Because then you learn, look, I don't agree with this person, but I know this person has the best interest of kids at heart. And you know what? I think we get there by point A, and this person thinks we get there by point B. But we all want the same thing for kids. So if I don't get my way, I get it. I will get over it. I'll get my way the next time, and we're going to move forward from there. I do recommend that board members spend some, even if it's just grabbing lunch every now and then, making an effort to get to know each other on a personal level is huge. Okay, this is the actual law. We've given you all this pontification, but here's the law. And you've probably seen this before. But this law lays out the standard for local Board of Education members. Basically, you have special roles. Your motivation should not be a climbing situation. It should be the improvement of schools and the academic achievement of all students, and that's highlighted. And Nina's already brought that to your attention. It's not just the students or the constituents, the parents in your area, it's all students in your school district.
And I'm looking at your mission and vision.
Yeah.
And y'all are already there. It's about getting to the highest levels for all. It's where all students are prepared to be successful and productive citizens. So every one of you needs to be focused on all, because that's how much effort it takes.
And that's where doing what's right for all students may not sit well with some of your community members. And that's where your communication and your relationships in the community are important, so that they understand, and as a board, so that your community understands the reasoning behind the decisions that the board makes as a whole, so that they understand this was done for the benefit of all students. And you may disagree, and that's okay. But again, we're moving forward together as a team. And that's something I've heard in my nerdy watching of your things. You all are very focused on that, and I think that is an amazing goal, and that is the right way to be. You already have a gift in that you're nonpartisan. That is such a gift that you can be on a nonpartisan board. It allows you to have conversations and agree on things and work towards the same goal without those labels mucking everything up. So it's amazing that you have that. So let's take that for a spin and think about all students, what's best for all students. And of course, this is not your run-of-the-mill office. You're not like a city council person. You're not like a state senator or a House of Rep person. That's not what you are. Your primary duty is not to, I gotta do what my constituents want. No, it is to represent kids. That's your primary duty, not to do what your voters want you to do.
And was that easier said than done?
Yes.
Yes, it is, because at the end of the day, kids don't get to vote for you, the grown-ups do.
That's right.
So part of your special challenge, while adhering to this commitment to serve all kids, is to communicate effectively with those people that can vote in those elections about why you're doing what you're doing and why it really is the right thing to do.
And communications as a school district is really, really hard. And no, every school district wants to do more communication, better communication. That's always going to be a challenge, but that goal of making sure your community understands why you're doing what you're doing and what your role is as a board member will help you immensely. Okay, more red flags. Don't be prepared for board meetings. Come, let it be a surprise party every month. Just come and see what happens.
We should do that one month, guys.
Just like, what? Who could tell. Be like my husband when I book a trip and we're on the airplane and he says, "Where are we going?" And he acts surprised, and he truly acts surprised because he has no idea why I booked this trip. Okay, be that guy. While work sessions, and this is a quote from Cognia. I pulled a few Cognia quotes out just so you can see what they had to say about this, because going back to this, one of your requirements is maintaining accreditation. And so what do accreditation people say about this sort of thing? Here's a quote: "While work sessions are an opportunity to ask questions and clarify understanding," absolutely, again, it's not theater, we're really doing work here. "If you don't know what's going on and you're misinformed, you're going to spend and blow a bunch of time asking questions and engaging in discussions that don't need to happen. You're going to get off topic. You're going to get in the weeds. You're going to get a fish or whatever stuffed animal you all decide on thrown at your head. And it's going to be obvious to your community you have no idea what's going on. Is that going to inspire confidence? No, not at all."
And you're also going to have a room full of extremely well qualified, extremely capable professionals sitting here at a board meeting, listening to board members ask questions that they should already know the answers to, instead of going back and doing their day jobs as well.
So you make that sound so lovely.
I know, but there's a lot. It's a lot.
A vast majority of our populace and community that pays attention wants answers stated on the record in a meeting, because then it doesn't look like theater. So that's a really fine line to walk on. Because yes, we can get everything answered, and then it is just votes and there's no discussion.
Yes.
So I know there's other board members thinking the same thing, because you get those people like, "Well, I want you to ask."
Yes.
And I'm like, it's a good question. I'm going to ask it.
And there is a certain amount of theater in that.
I mean, yes, there is to some degree.
No, I said that is the theater. That is constructively choosing the thing that needs to be a sound bite, and not just making everything a sound bite. There are some things that people need to hear because they need to know that we're talking about it, and they need to know that we understand it.
Yeah, some things do need to be a marquee, some things do need to be a headline, and buried on an agenda item summary isn't the best way for the community to learn about a detail.
That's right.
Absolutely. But if that happens for every aspect of every agenda item, you got a problem.
Yeah, that's absolutely right. You may strategically choose questions in advance. There may be some that happen organically. That's okay. It's okay to ask questions. You don't look unprepared just because you have questions. But I have been a part of many conversations where board members say, "Okay, I'm going to ask this," and you to the superintendent, and can you be ready to answer this question, or to the presenter? We just want to make sure you're ready to answer this question, because definitely the community needs to hear the answer to that on the record. That's fine, perfectly fine. That is strategic and that is planning. But getting here and saying, "We have school buses? Who knew?" That is not what the kind of image you want to give to your community or your accreditors, right? Not knowing or not implementing policy. I know you have a lot of policies, but once a year, get a glass of wine and read them. Just read them cover to cover. I know it's a lot. It's a lot. Maybe more than a glass, maybe something else, maybe some chocolate, whatever your thing is. But read your policies once a year-ish so that you know. You don't have to be an expert in them, but at least it'll trigger something here. Wait a minute, we have a policy on that. I need to know about that. Or it may make you say, this policy is really out of touch with how we do things. Okay, more red flags. One thing that will set off alarm bells in the community and will tear you apart so fast is a lack of trust. You need to be working on your personal relationships, not only with each other, but with your superintendent. Also, bickering in front of folks. Now, bickering happens. It does. Because you're kind of like a family, and you're kind of going to get on each other's nerves sometimes, and you are going to disagree. But the bickering and the little things, those can get in the way of the big conversations. It's okay to disagree, and it's okay to disagree strongly. That's fine. But the yin back and forth that isn't really accomplishing anything, that is not going to help you get work done. It's not going to help your staff know what you expect from them or your superintendent. And it's going to make you look, as this accreditation report said, embarrassing, sad, and scary that the board members were bickering the way they were. So
And I want to hit on this trust issue. I think one of the quickest ways to destroy trust is to not keep confidences from executive session, both amongst board members and between board members and administration. Executive session is private for a reason. You are discussing the heaviest of the heavy topics in executive session, whether a child should be put out of school, whether an employee should lose their job, high stakes litigation, all those kinds of really private, high level things where there is value in confidentiality, because the value is everyone being able to speak freely and have a free discussion, knowing it's not going to come back out to haunt them or haunt the district if you let something out of litigation, litigation discussion go. And if you get back in that room and you're not confident that you really can speak freely, you're not going to trust each other. You're not going to have those necessary conversations that you need to have, and you will be weaker as an organization.
All right, here's some more quotes. This is eroding trust as well. And just as Nina said, confidentiality, even if it's not executive session things, maybe the superintendent gives you a heads up, hey, I'm working on this, and I'm probably going to put it on the agenda, or it might show up here or there. And then you go and you post it on social media and say, hey, guess what I heard? That is going to be problematic, first of all, but also is going to erode that trust. Also, our friends' social media. I've got a whole training just on social media for board members, but being careful how you use it. It can be divisive and not constructive. And if you can absolutely run afoul of the law, you can run afoul of your board policies. You have to be so careful how you use it. So social media can be a great tool. It can also be dangerous. So making sure you understand the right way to use it and the appropriate way to use it is really important. And if you feel like, I don't really know how to use it, then you might want to wait until you feel more confident to really use it. One thing I say to board members who are kind of like not super comfortable with social media, but they still want to get the word out to their community, all the cool stuff that's happening, they'll start, the safe thing to do is take your district social media posts and share them.
Just repost.
Yeah, repost those. And I promise you, the schools, between the schools and your school district, they are pumping out some amazing stories. Put that stuff out there. Or if there's a good media article about something awesome you're doing in the district, share that. That's a good way to start, and it's a safe way to communicate with your folks on social media. Okay, and here we go again. Using blogs and emails to encourage, now this is an older case, but blogs aren't as big a thing, but basically using technology to encourage feuding. It's also this whole idea of the board is not speaking with one voice and is not acting as a team. And that the board members are, look at this last line, catering to their individual agenda and constituencies. It's a no-no. And this is out of North Carolina, but that would be true in Georgia too. You should be catering to all students, not to your individual constituents or to your individual beliefs. You should be catering to the students and what's best for them. And sometimes you gotta look to the data. You may have an idea of what's best, but the data says otherwise. You've got to follow the information that's being provided to you. Okay, so other ways, if you want to make your life difficult, not understanding how meetings work or how to get items onto the agenda. Nina and I both have been to so many board meetings where board members are incensed that they can't get something on the agenda. And honestly, it's just because they don't know how. And they've never asked anyone how to do it. And it should be very easy for them to do it. Also, taking any private action that's going to compromise your board. In this situation, a board participated in a drive-by protest. Taking any action in your private life that can compromise the Board of Education is something that you should avoid, and it's something accreditors will look at.
And what I like to say is you're never not a board member.
That's right.
You cannot take off that hat. It is always on.
That's right. And same with lawyers.
Yep.
Even though Sean has left us, he'll watch this later for credit. We can't take a hat off. We cannot stop being lawyer. We can't stop it. You can't stop being a board member. So just keep that in the back of your mind when you're dealing with things in the community. And then, of course, you don't want to be the cause. And accreditors have hit back at this, board members for this, saying basically, you got, not y'all, but this board or a board can be so wild and woolly and dysfunctional that it take, like on Monday, or the next day after the board meeting, all the staff can do is, number one, wring their hands about how wild the board meeting was, but also try to clean up the messes or fix the problems that board created at the board meeting. And the accreditor said, that's ridiculous. That should not be what staff spends their time on, is cleaning up the messes that the board creates. You're supposed to help, not hurt. All right, so that is the end of our content. We are
Right on time.
very close to the end, yes. We are happy to answer questions. We know this is a lot. If you look at the placemat on the back, there's a list of topics that we train on. It's not exhaustive, but it gives you ideas. If there's anything we can help, again, you have legal counsel, we assist legal counsel, we assist boards with training. We're always happy to be as assistants. If I've said anything to you that you're interested in, you want more information on, I know a few of you've asked for a few things, we'll be happy to get those to you. We are happy to be available to y'all. And you have our email address,
Please
and
feel
I
free to
will.
reach out to us anytime. And do sign up
Yeah.
for the client alerts and our
Yeah.
executive order briefing team to get alerts on us. So there's a QR code on the front of this deck.
I'm gonna email you this deck as well.
Yeah. So there'll be a QR code you can sign right up, and hopefully that'll be of some value. But at least there's literally no investment you have to make other than signing up your email. So.
And I encourage you, as part of your whole board governance training process, you do need to think about what your training needs are going forward. So I think you've already identified some things you're interested in, but be thinking about that as well. And it doesn't have to be us. You can use any certified trainer.
Right. But we're happy to come back if
Yep.
we can be of use to you.
Thank you. We appreciate it. Y'all are a very Oh, you're so welcome. Thank you. And I will say this, you all are approaching that. We always kind of think of this, when you get close to the $1 billion budget mark,
Yeah, that's a different kettle of fish, isn't it?
you're in a different league.
Close.
Yeah.
You're very close. What are you in the high 800s? So you're going to start, if you haven't already, you're going to start going to trainings for around the state, and you're going to be sitting there and you're going to be thinking, this isn't helpful. And it's because
Well, you're in the top 1% of districts in this state. Do you know that there are more students in Gwinnett County schools than in all of Montana? Wow. Yeah. You've got 30-something thousand kids here. That is a third the size of the entire state of Montana.
it's huge. So if you go to trainings and you think, this isn't helping me, why is it not helping me? It's because you're operating in a different wavelength, and that's okay.
Yeah.
You just need more and different. All right.
I just have to jump in here and say, this is why the adjacent counties are not really comparable districts for us when we're looking at these data and people are asking, why are we not looking next door? That's why the comp districts are our comp districts. They're not nearby, but they are comparable in how they operate.
That's right.
All right. Thank you. All right. I'll take a motion to adjourn. Yes.
Can't turn it off.
Let's go. Thank you guys very much.
Of course.
This is fantastic.
Our pleasure.
This is much better.
Okay.